Hear ye, hear ye.
I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial daddy.
I want to give a big shout out to the 13th Juror Podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, we'll have some coffee.
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Hello, friends. Hello, family. Good morning. Good morning. Big day today. Big day. Big day. Come on in. Grab your seats. Get a biscuit. Taste the biscuit. Taste the goodness of the biscuit. Let me get everything pulled up. Good morning, good morning, good morning. It's been a day. I did a long day yesterday. Working on the podcast episode because we will be having the hearing from today included on the episode. So I tried to get everything done that I could yesterday. My mic is low. Normally people tell me that it's like too loud. Is that better? Is that better? Normally people are like, your mic is too loud. So then I turn it down and now it's too low. That's okay. Oh, still low. Let's see. Is that better? Audio, is that better? Microphone, Yeti microphone. Oh, let me try this. Actually, there's like this little button, automatically adjust mic volume. Let's see. How's that sound? I like it when people just automatically do things for me. By people, I mean AI. So good morning. You can barely hear me. Okay, but then when the court starts, then y'all are going to be like, oh my God, it's so loud. It's so loud. All right, we'll see. Okay, so good morning. I don't know if you have seen it or not, but apparently today, this morning, the morning is going to start out with Turtle Boy and Karen both sitting at the defense table in one room in front of hold on, let me pull up his tweet. Oh yeah, Proctor, we got to talk about Proctor. We got so much to talk about. Let me pull up the tweet. Tinsley snoring, and it's adorable. Okay, so Turtle Boy said, tomorrow is going to be interesting, and this was yesterday. Karen Reed and I will be sitting together at the defendant's table in the main courtroom at 9 a.m. in front of Judge Doolin. Hank Brennan is interceding in my case for a Rule 17 motion from my phone. After that, the hearing will move into the small courtroom for a motions hearing with Judge Canoni. So I guess they are starting out with Judge Doolin this morning. The reason that is so interesting is because I'm like, okay, well, that must be the reason why Judge Canoni didn't want Betterow on this case. What I don't understand is if the grand jury returned a no bill on them for witness intimidation, for conspiring to do witness intimidation stuff. If the grand jury, which is like the lowest bar that you have as far as indictments and stuff, if they returned a no bill, I don't know how Brennan is still trying to go after this. I had said I think that he's going to put Turtle Boy on the witness list so that Turtle Boy won't be able to be in the courtroom. I don't think he has any intention of actually calling him. I think that, because who would want to put, would you want to, if you were Brennan, would you want to call unpredictable Turtle Boy to the stand? No. He doesn't want to call him. That's just what I think. I could be wrong. I've been wrong before, I'm sure, at some point in my life. Just joking. But I would not, if I were a prosecutor, if I were Brennan, I would not risk putting Turtle Boy on the stand, not knowing what he would say. So I don't think that he has any intention of calling him to the stand. I think that that whole thing was just to get reassurance that he wasn't going to be in the courtroom. So, but what do I know? And not only can he not be in the courtroom, but he can't do shows about it because he's not allowed to watch the trial. So, I don't know. I don't know. All right, let me get it pulled up. We'll go ahead and start. Start our little feed. We'll start watching. What just happened? What happened? Do y'all see me? Do y'all hear me? My screen just went black on this. Hold on, don't go anywhere. I'm going to refresh this. Okay. That was weird. Everything on StreamYard went black. I couldn't see it. All right, so let me share my screen. Proctor has been fired. So in case y'all didn't see that yesterday, that now this one's going black. What is happening to my computer? It's aliens. Thank you, Dave. Thank you. Get yourself a new beach towel on me. Thank you. I appreciate it. I appreciate it. aliens. What is happening? There we go. Hold on, I'm changing a few settings real quick so that hopefully that doesn't happen again. Weird stuff going on around here, guys. There we go. Okay, all right, maybe that should work. Let's see. We'll see. We'll see how it goes. Also, we have Lori Jean, new member. Welcome back, Lori Jean. Welcome, welcome. And April B12 gifted a membership. Thank you so much. Thank you, thank you, thank you. Oh, that water's so good. Yeah, Proctor gets no pension. He wasn't there long enough, so he gets no pension. You know, I've seen a lot of people saying stuff like about how, you know, oh, it was just mean tweets. It's nothing, you know, he'll be reinstated and it's more than mean tweets. And if people actually took the time to read the document, it's more than, or not mean tweets, mean text, mean girl text or whatever. It's more than that. It's a lot more than that. And minimizing it is basically saying that it's okay what he did, and it's not okay what he did. And the thing that I don't understand about any of that is that if you believe that she's guilty, you should also be really pissed off at Proctor. So that's the thing that I don't understand, is that how are people who think that she's guilty, if you've reached that conclusion, how are you not mad about Proctor as well? Because you should be furious. Because if you think that she's guilty, then that means that somebody else's actions, as in Proctor's actions, have now caused, you know, potentially caused this whole investigation, or have caused this whole investigation to go off the rails, and have now potentially had an impact on the case, in that, you know, it could, you know, end up in her acquittal. And if you think that she's guilty, you should also be mad. And I don't understand how people aren't. I maybe I'm missing something. I don't get it. I don't know how people aren't mad about that. I really don't. So, has this thing ever been on the rails though? No. The rails were gone when the solo cups came out, I think. I'm praying that Proctor's firing will give Bev an excuse to grant the motion to dismiss. I don't see it happening, because they do not want to give up on this. It feels vengeful in a way. I think that, you know, they are all really, really mad at Karen Reed and the defense and everybody who's saying things about them. And I think that this is one of those situations where they are going to do everything they possibly can. Because look, even the murder charge, the murder charge, everybody knows that's a reach. Like, the jurors all agreed, you know, that's it. That's like, no. Oh my gosh, you know, she like told some girl in Aruba to go F herself because she thought that she was kissing John, so she totally murdered him. No, like, these things are not logical. That's not a logical argument. So I think that the murder thing is such a reach, but they're not even letting that go. Like, they're still pushing for that, hoping that that sticks. it's like, they're trying to make fetch happen, and I don't understand it, because I feel like if I were the prosecutor in this case, I wouldn't prosecute it. I'd be like, oh, right. Like, you don't prosecute cases that you can't prove beyond a reasonable doubt. So I wouldn't prosecute it, but I'm not a lawyer. I just talk about lawyers on YouTube and a podcast. So what do I know? But also, if I was a lawyer and I was a prosecutor and I was going to prosecute this case, I definitely wouldn't be prosecuting it for murder. The manslaughter is the, closest you can get to having a chance at something, I think. I don't see how, and but we also know that Brennan's coming in playing dirty. Like, justice is not his thing. That just ain't his thing. He's all about winning, and he wants to win this case, and he has proven that over and over. The hypocrisy and the way that he will do the things that he's arguing about and saying are wrong. Like, justice ain't his thing. He's smarmy. So I don't know. What do I know? I'm not a fan of his at all. Oh, it just told me signal lost. Why does it say signal lost? Well, let me share my screen. The fan was on, and now it's gone. Let's see. See if the other one comes up. They may have turned the feed off because they're waiting on the other hearing, the one with Turtle Boy. So I didn't see the Turtle Boy stuff televised. Hold on, let me swap feeds. I think this one's behind. Oh, it's on Zoom. Let's see. Let me pull up Tom, because I've got the other one. What is happening to this? Hold on, I'm going to pull up Tom's string because I can't get it pulled. I can't get I'm having computer issues. Hold on. Hold on.
Mr. Carney's case. Because of that, I have from the beginning kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available. That's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket to Mr. Carney's case.
This is Boston Mike's.
Because of that, I have from the beginning kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant. And the information is relevant material to Karen Reed's case.
I'm fixing audio.
The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I've refrained.
Let me ask you this, Counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney, in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the Addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through and including October 5th, 2023, 7 months of material that ostensibly could include everything from meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reedstein unless they have standing in this.
Your Honor, we're a little confused, and I don't mean to interrupt the proceeding, but as we're...
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of the Prosecution. We didn't see which case number was called for this Rule 17, if it was Mr. Kearney's case number or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Canoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said yes. The Rule 17 that Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights and the issue.
This meeting is being recorded.
Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here, and she has a right to counsel, and we have a right. We believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that that's, yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but we...
Which can be dealt with at a later time. Those are, what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lampron hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or an admissibility standpoint, that can be dealt with at a later time, but the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth, there's been Rule 17s for 2 years on this case, over and over and over, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number, and the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. Correct. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're prepared.
And did you give the court notice of that?
We did to Justice Canoni.
Okay.
Day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues that Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration of the court such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes an ultimate ruling, and once Mr. Bradle is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Judge, I have no objection procedurally if counsel wants to join in my file if that's an issue in terms of a filing. Just put it
Thank
down.
you. Thank you,
Well,
Attorney.
Your Honor, I do object. Ms. Reed's counsel and Ms. Reed do not have standing for this motion. I don't believe they should be sitting at the table for this motion. It's a Rule 17 motion of third party. She has no privacy interest in these materials. She has no standing to object, and she's not a party on the Rule 17.
Thank you, ADA Brennan. She is a party in this case, and I'll allow her to sit at counsel table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
So,
Oh my gosh. Oh my gosh.
ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and I've identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, it's Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination of digital material seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an aired broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available, and if the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer. ADA Brennan, thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of this sharing, and inevitably the obvious consequence to witnesses, this is relevant to consciousness of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials will be provided to Judge Canoni in a motion in limine regarding conscience of guilt. Also, we'll dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Kearney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
No! Come back.
Counsel.
Thank you very much, Your Honor. Good morning, Your Honor, counsel.
Morning.
Judge, this is a Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning it has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor.
That's what I said
Sitting
earlier.
in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me, counsel.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of, not even so much representing Mr. Kearney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this. I read the search warrant, out of the Herald or something. And I was prompted to write this press release that I sent out about this exact issue. And I went back to it, I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it. You know, we have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants, and talk to anyone she wants, and communicate with anyone she wants, and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and failed. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong, the government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Carney in consciousness of guilt unless it was, quote unquote, the door was open, which of course is sort of a proposition that is, you know, out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, hey, let's really get that person, and let's get them off of this, and let's try to have that person not testify. Let's scare that person. Let's harass that person. There's no communications like that. They just have the fact of communications. And that's not evidentiary. That's not relevant. So, Judge, here, they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in our client's phone, in my client's phones, Your Honor. So there's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right. Went to say that, oh, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of...
Counsel, what's the legal import of the pending motion to dismiss in Mr. Kearney's case?
Sure.
How does that change either the relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure.
I love
So we
this
expect
judge. He
Judge
asks
Doolin
good
to come back with a
questions.
decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, well, they communicated. The fact that they communicated cannot be a basis for a criminal investigation, and it's the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is from Commonwealth versus Onyx White. that is a landmark case that involves the notion, and you know, the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime. And it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime. And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home. So
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District Attorney's Office. It's in it's in Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have happened.
That issue isn't before me, counsel. That issue isn't before me. The issue before me is what he's looking for relevant.
Right. What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary, it's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor, that just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them. And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife communications.
Counsel, you're not asking?
No, not you. Just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications. We're asking for the journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Lillard, Your Honor.
Thank you, Your Honor. Elizabeth Lillard here on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue. The defense joins in Mr. Bradle's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look... Attorney Bradle. Apologies, Your Honor. There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel.
Those are two
AD
big
Brennan, I'll
points.
hear from you in response briefly.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradle. It is this reflective of consciousness of guilt?
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was some suggestion there was an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless...
That is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed. That is an entirely separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition. It's an entirely different proposition than opening the door to the state of mind. The consciousness of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protected information, to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Canoni if appropriate, and then she should decide the admissibility in the Commonwealth v. Karen Reed trial. Thank you.
Thank you, counsel. Folks, I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today, and I'll endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes, and my teenage...
What the heck just happened? So how did Law and Crime just go to a random morning show? I don't know. I don't know how these things happen. What are we thinking? How are we feeling? That was a lot. So hold on, I'm going to swap feeds to this one. Let me change that volume. There we go. Okay, so I'm a little bit Hank just admitted it was a fishing expedition. I think that how is it not a fishing expedition? Consciousness of guilt is wild. To try to get to consciousness of guilt through them saying that they communicated. That's like, say, okay, how many cases have we seen where, defendants have talked to journalists? That's oops. It's a full screen. So yeah, I don't agree with that. What are we doing here with what's happening here? I guess they're swapping everything out for the next hearing. Yeah, I don't agree with that. It's definitely a fishing expedition. The consciousness of guilt thing is hard for me because how could you say that that's consciousness of guilt? Them communicating is not consciousness of guilt. And we know that there's not any evidence of them arranging any type of harassment because the grand jury didn't find that. So it's a big stretch. And I like that this judge is, oh gosh, this judge is so different, right? Oh my gosh, if only we could have this judge for the trial. Imagine how different that would be. Like, this judge not putting up with any nonsense. How different would that be? And also, okay, let's say she's totally innocent and these people are covering stuff up. Of course she's going to be pissed. Of course she's going to want, the truth to get out there. That wouldn't be, to me, that wouldn't be consciousness of guilt. That would be more like, I don't know, whatever. It's not a surprise that I disagree with Hank on this. I disagree with just about every single thing that Hank has ever said. And saying that Karen seemed to encourage it, like that's just another one of his what? This documentary is really giving old Hanky delusions. I haven't seen it yet. I haven't had time to watch it. I like that he challenges the person who wants the motion. I like that he actually doesn't like he doesn't just let all of this stuff happen. Like he actually asks questions and he wants to know. One thing that Brennan is really big on is throwing in a whole bunch of crap that doesn't matter to try to deflect from the fact that what he's saying is BS. And he does that a lot. Like a lot. And it's really annoying. And I like that this judge was like, nope, we're not doing that. You focus on this issue. I like that because without all of the extra telenovela bullshit, it makes it so that you can actually focus on the issues instead of all of the extra crap that Brennan says. So I don't know. I liked that judge. Gosh, it is amazing what a difference a good judge makes. If only, man, if we could have that judge, man, that would be awesome. But such is life. We don't always get what we want, I guess. So very interesting. I think the two biggest points, or no, I won't say the two biggest points, like the constitutional stuff and all that, like the, that stuff, I get it. But I think that Miss Little only argued for just, like less than 2 minutes, but she made two very, very big points. Number one, the whole thing about like, because with Lampron, it's like, I can't remember how it's worded exactly, but it's something about how like you can't, if you don't get this information, that you can't properly prepare for trial. If you don't have this evidence or information or whatever it is, that you can't properly prepare for trial. That's BS. You can properly prepare for trial because you've been doing it for, how long now? And now you're wanting this information that has nothing to do with anything that happened on that night. It's nothing. And then the other one was that the Commonwealth is required to show that this is not a fishing expedition. And this is like the definition of a fishing expedition. It's like, oh, they talked. They said that they talked. Let me see what they said. That's a fishing expedition. That is like the definition of a fishing expedition. All they know is that they talked. That ain't breaking news, y'all. That ain't breaking news. We've known that. But now it's like, oh, we're right before trial. I need that. They said they talked. That means she talked. They communicated. I'm gonna need that so I can fish through it and see if there's anything I can use. No, that's a fishing expedition. I don't know. We'll see. I think that they are going to try to use everything they can against her. I don't think she should have done the documentary, but I haven't watched it. I say that without having watched it. And the reason I say it is because I almost always, I think there's only one time I've thought like, yeah, that was a good idea for, that defendant to take a stand, and that was Travis Rudolph. But 99.99% of the time, I think it's a terrible idea for defendants to take the stand. And I think it's a terrible idea for them to do like any kind of interviews with media, because media will go with what the media will do with whatever they want. You have no control over it. So and you never know how you're going to come across. Because think about it like this. Okay, let's say she's innocent. And she's pissed because they're doing this to her, right? Hypothetically. You're going to be pissed. You're going to be mad. If I'm getting, if we're assuming that she's innocent, presumption of innocence, right? If we're assuming that she's innocent and all these people are covering stuff up, like this little family and group of friends are covering stuff up, I'm going to be pissed and I'm going to be snarky and I'm probably going to say some colorful words and I'm probably going to make faces because y'all know I can't fix my face. All of these things will happen. Okay, now imagine that people who don't know anything about the case are seeing this on TV and they're going to see me being snarky and they're going to see me rolling my eyes and they're going to see me being pissed. But as much as we are supposed to give the presumption of innocence, when you are watching a documentary on a person who is on trial for murder, that's not how people go into that. That is how jurors, go into trial or should go into trial. It is not how people perceive things instinctively, though. And that's the problem. So if you're seeing somebody who is on trial for murder, who is making faces and is snarky and is pissed, that can come across as them not caring about the victim or not having any remorse about anything that happened or whatever. And people will read into that. She may, if she's innocent and this is happening to her, she has a right to be pissed off. Any of us would be pissed off in that situation. But that's not what people that are seeing it are going to always see or think or keep in mind. You know what I mean? So I feel like those are things that if you have lived and breathed this case, then maybe that's something that you acknowledge. But if you're just a random, person watching this on Discovery for the first time, or if you're a person who already thinks she's guilty, then that's not what you're going to see. You're going to see what you want to see, or you're going to see something negative, and that's going to be used against you. I think it's a huge risk for that reason. So, I don't know. I know I couldn't do a documentary because I cannot fix my face. Cannot fix my face. She smiles at the worst times. I think a lot of us do that. I tend to smile when I get uncomfortable. So, I don't know. Yeah, they're supposed to be coming back for the hearing. The next hearing is going to be right after this, so they should be coming back any moment. Hank is looking for any kind of dirt. And I feel like that has given us some insight into how he's going to play this. Talking about all these interviews and talking about, like wanting these communications and all of this stuff. He is not going to present this case with evidence of what happened. He is going to present this case with everything he can to make the jury hate Karen. Because he is wanting, this is my speculation. Hank speculates, I'm allowed to too. It seems like he is wanting to find everything he can to present to the jury to make them dislike her so that they will convict based on that, or, because we know that happens, or that it will color their view of her in such a way that they weigh the evidence differently. Because think about it like this. If you have think of a defendant who is a total douchebag but wasn't guilty of what they were being accused of. Think about I can't think of anything off the top of my head, but I know there have been some. But anyway, think about a defendant who is on trial, and I'm not saying that she is, I'm just saying roll with me here. If you have somebody who is very unlikable and they're total a-hole, rude, whatever, you don't like them, but there's not evidence of them being guilty of this crime, it is really hard for some people to separate those two facts. Like, which is the whole reason that they don't allow certain things in that are prejudicial as opposed to probative. Think about the Melly case. They didn't allow pictures of him in with, holding guns and stuff, because that could give the jury the impression like, oh, he's like showing off his guns and he's doing all these things and he's, listened to the lyrics of his songs and whatever. So yeah, he probably did it. Those are not things that are evidence of that crime. That's him being a cocky kid on social media. Two very different things. That's why they're not allowed to see, the jury's not allowed to see that. It is hard sometimes for jurors or people in general to differentiate their personal feelings towards somebody, to put that in a separate box when they're weighing the evidence against somebody. And it seems to me like
117, the Commonwealth versus
that's
Karen
what Brendan's
Reed.
doing.
Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Barbara McLaughlin for the Commonwealth. Good morning, Ms. McLaughlin.
For the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Unetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read. What I'd like to start with, it's paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're defending all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice, and we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance, and I'll submit.
All right, does the Commonwealth want to be heard on this?
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in
I knew that was
were
coming.
summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st with impanelment.
Thank you, Your Honor.
Okay. All right, so let's go to the next motion, and then we'll go back to doing them somewhat in order. Commonwealth's motion for a buffer zone. Jimmy, do you have an extra copy of what you just handed me? Because I don't know where I put it.
Can get one.
I have it here somewhere. I'll find it.
Okay, so the buffer
we
zone they're
did
wanting to
hear from
extend.
people this morning. I know you all have. I have it. I have it, Jim.
Thank you.
I think Mr. McDermott gave you a copy of, I guess, what local merchants have requested.
We've received it, Your Honor. Thank you.
Okay. All right, so I'll hear the Commonwealth on your buffer zone motion.
Your Honor, the Commonwealth's primary concern is the sanctity of the jury and the jury process.
No, it's not.
We are concerned based on past reports and information that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence to the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being wholly familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate but related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury. I don't think it is a strong imposition to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing or enforcing the buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit. And so I don't think that burden should be imposed upon the court.
Thank you. All right. With that, does the defense object to the buffer zone?
We take that position.
Okay. All right. I'll take this under advisement. I have to figure out exactly how far this is. And I have not yet had a chance to read and consider today's email from the merchants. Okay. Yes.
Okay, so that's all about the buffer zone. So I have it basically like it goes over a bunch of different streets that they wanted to include in it. They said that the jurors said that they could hear last time a lot of honking, and then they could hear like yelling or chanting or whatever when they were during deliberations. But the part that she's talking about, okay, so he says that he wanted to expressly include a mechanism for its enforcement where a person, okay, so where a person is believed to have violated the buffer zone provision and has refused requests to comply, law enforcement personnel should be authorized to use reasonable force and to arrest that person to ensure compliance. So he wants them to be able to use reasonable force. And so she's saying that's not a court thing, that's a law enforcement thing.
Can I just have this marked for identification for this hearing, identification? And from the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report anyways. All right.
Your Honor, can I be heard on that one issue? Just briefly.
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
Imagine that, not complying.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from...
I don't have a problem with that. I still need cities and towns.
Of course.
Okay?
Yes.
All right. Thank you. So we will start with paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias. Who's
So
arguing
this
that
is
for
for the
Commonwealth?
ARCA.
The Commonwealth first, Your Honor.
Oh, it's defendant's motion. The Commonwealth opposed it.
You would ask who's arguing that for the Commonwealth. That's
I'm
why
sorry,
I-
defense motion. Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever the...
I'm fine with him going first if you'd like.
Okay.
Okay, so this one is about the ARCA lack of bias. So the defense is wanting to be able to tell the jury that it was the Department of Justice that hired them, not the defense, not the Commonwealth. If they want to bring up, oh, well, the defense paid you to come, testify about your findings, whatever. But they're saying that the whole point of not telling them was because they didn't want the jurors speculating on the federal investigation. And they're saying, look, we won't say anything about the federal investigation, but we should be allowed to tell the jury who hired them, because we know from what jurors have said now that this whole thing about trying to keep them from speculating actually had the opposite effect. It made them all speculate, and then they're thinking that it's like the insurance company or a random person or the Reeds that hired, or fame seekers, whatever, that like they're thinking there's all these other people who just jumped in on this case. So they didn't take the weight of that testimony seriously. So the defense is not wanting to mention the federal investigation. They're just wanting to mention who hired them to do their testing and what their testing was for. And of course, Brennan opposes.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report, and then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA, and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is an undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know just inherently from that information that there is more. There are more communications, there's more interaction. And so it would be...
You don't know that. That's speculation.
...misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts and report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told, what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a Lanigan hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned, as they should, well before trial, in my opinion, we do not have the opportunity to question the United States Attorney's Office. We resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case in all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently, and then subsequent to that, the defense retained them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 or 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 or 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just ask them the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Mr. Yannetti?
Thank you, Honor. Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARCA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARCA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the federal government having retained ARCA, the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate, right?
But the point of the fact of the matter is, Your Honor, they did speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance company. And think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, how does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So no, could you answer that now, and then I'll let you say everything.
I'm trying to, Your Honor.
Oh, you just said it's late. Hold on, you just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say, but I'll address it now.
No love lost between them.
We are not asking that the jury be told that there is or ever was a federal investigation. That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved, and it all inures to my clients, to prejudice my client. Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA.
Okay, I did not know that.
And they did that again to preserve the scientific integrity of their...
Okay, hold up. I did not know that. I did not know that Yannetti received everything that has been said up to this point has been like, oh, well, the defense just gave them what they wanted. The defense just turned over whatever they wanted them to have. They didn't, I didn't give them this. The Commonwealth didn't give them this. This is the first time that I've ever heard that he was hold on, I want to rewind it.
What to give that the Commonwealth provided to us, to the federal government. And I for my entire...
Hold on, sorry.
To establish any of that, I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA, and they did that again to preserve the scientific integrity.
That's a big deal. I've never heard that before.
So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with, and all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship.
Real quick, I want to clear this up. Yes, ARCA said that in the last trial, the feds gave them the info and made that decision. It was testified to. Yes, but what he's saying is that, okay, so Lally and Brennan have both been like, oh, you know, the defense is the one who turned whatever they wanted to over the feds. It's always been this implication that the defense just cherry picked whatever they wanted the feds to have, and that's what they turned over. So this is the first time that I've ever heard Yannetti say why they turned stuff over or what had happened. He was subpoenaed for his entire case file, and he turned over every single thing that the Commonwealth had turned over to him. So, and then the feds took that, and then they decided what they gave ARCA. But the entire time, this whole 84 years that we've been going through this, Brennan and Lally have both been implicating that the defense just picked what they wanted to, what may have worked best for them, and handed it over to the feds, being like, here you go, use this. And then they would give that to ARCA.
Was, or, you know, what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Okay. Any follow-up?
Yes. Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate's side of the truth, the whole truth. And if we interject that these witnesses were hired by the federal government and the jury is entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered, and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship with the federal prosecution in this case or their investigation. We didn't have any interaction, not because we chose to hide from exculpatory evidence or we were hiding from the truth. We weren't invited. We didn't know. Now, I hear now that Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023 describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last time.
All right. So
I think it's really funny that Brennan's talking about holding people in check. Like, who's going to check him? Who's going to check me, boo? That's what pops in my head. If if he wants to hold everybody else in check, but nobody's checking him, nobody's holding him in check, nobody's correcting his. Okay. All right, Brennan, sit down.
So if the defense intends to call the ACCA witnesses, we need to have a voir dire next week.
Of course,
All
of
right.
course.
So
Let's do another
we're gonna
really
move on. I'll
expensive
take
voir
this
dire.
under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any objections later.
How is this?
All right, so the next motion is the defendant's motion for stating grounds for objections. I'll hear you on that, Mr. Yannetti.
Man, it just keeps getting worse.
Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
During the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that we have a jury sitting for weeks at a time away from their families, away from their jobs, and any sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection, and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Oh, I understand, but it's what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know it.
I agree with that.
And
We
I'm-
should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights. And
I don't know why
we'd
this
ask the
wasn't
court to,
done the first time.
To change its ruling from the first trial.
Okay.
Now this is something that seems so like a no-brainer for me, especially to preserve the record. But what do I know? I'm just a podcaster. But they're not asking to have like full speaking objections where they give like arguments or anything in front of the jury. They're only wanting that one like the grounds, they're only wanting grounds of why there's an objection. If, like he just said, like if it's, objection hearsay or objection foundation, just one quick little, like, this is the basis of what it is so that the ruling can be made. I don't understand how it's not a thing, but Bev just does what she wants to do.
That motion is denied. So the next motion, defendant's motion eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right, so that motion's allowed, Ms. Giannetti. There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Alessi, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can address it later.
Thank you, Your Honor. And
Okay.
also, just so I'm clear on that, and to the extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after
Thank you.
Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So
But not the Commonwealth?
there's that. So I think now we move on to something that may take a little bit more time. The defendant's motion eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant, and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alessi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Okay. All right. Before we go there, there are a couple of the Commonwealth's motions that seem pretty quick that I just wanted to know if the defense had objections to.
I'm like, it
To
gets
appoint a
worse and worse every
stenographer,
day.
we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number 1, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes appointing a stenographer is a prudent practice.
We've already done that.
Okay. Preventing identification of jurors, this case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
All right. Any objection from the defense?
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well, that's what I'd like to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a change.
This is a new trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority, and I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information. whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right, so I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the one photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to that, Ms. Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan, paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. I'll hear you on that. Yes.
Pursuant to Mass case law, Commonwealth v. Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different from questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted, and it should follow Massachusetts general laws, and it should follow Massachusetts case law. And for those reasons, we ask the court to redact any cause of death in the death certificate itself.
All right, who's arguing this for your defense? Ms. Little?
Thank you, Your Honor. In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redaction.
Hold on. Hold on. Hold on. He just said that they don't want it on there because he doesn't want Proctor didn't get them to say it's homicide, so they don't want it on there. He just said he didn't want it on there, and he said, but the defense can cross-examine about the manner of death. The defense can cross-examine a witness that we didn't call. She just got up here and was like, they didn't put the medical examiner on the witness list. Seriously? He just said they can cross-examine on this. But he forgot to mention that they didn't put the medical examiner on. Okay, go ahead.
Acting the word homicide because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined, and that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred, and the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw her. Dr. Scorti-Bello? Oh,
Not on their witness list.
right.
Busted. That. Hank's gonna Hank. Hank is gonna Hank.
Witness list.
So they did put them on the witness list?
All right. I'll take this under advisement. I'll take a quick look at Ellis again.
They're saying not on the witness list. They're saying,
I would just note, I apologize. I know Attorney Brennan did represent at one point that they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you.
okay.
All right.
I was gonna say.
One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the Registry of Motor
I
Vehicles.
started flipping through those
Is there
papers
objection
quick.
to that, Ms. Little?
No objection.
Okay. Probably one more quick, so that's paper 580, Jim?
Thank you.
Commonwealth's motion eliminate with the intent to obtain Corey records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that? Aaron?
Sure.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
Is it the common practice in this office?
Your Honor, is the court's question common practice of giving everything, or is it the common practice of running queries?
It actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, there may be people who have a criminal record in re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. And I understand may have happened in this case, has happened in many of my cases, and the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all, too, to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up, and I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial there's somebody that says they forgot to say something, or they had a record that, you know, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're
But
giving the jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the
Good
motion?
point.
But if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time, and we'll come back and we'll do that motion, the defense motion regarding Dr. Welcher.
All right, please.
You are muted.
Okay. Skip to live. Well, isn't this an interesting morning? Very interesting. Okay, so I ain't gonna lie, y'all. I am struggling with Bev. I really am. It has been getting progressively worse, and I am just being honest with all of y'all. My 4,200 viewers right now in the different platforms. I'm just being honest to y'all about where I'm coming from. I am struggling with Bev. I feel like I have tried to give her the benefit of the doubt, and I have said, even in a few of the podcasts over the last couple months, I've been saying that there were some rulings that I thought that were really fair from her. And then that has, it's like, you know, that has gone downhill. It is really difficult to continue to watch the double standards, and it is really difficult to continue to watch rulings that should be a no-brainer and in the best interest of everybody involved. And she's like, nope, denied. The one about the speaking objections, they are not asking to have an entire conversation about anything. All they're asking is for what every single other court freaking does. I can't think of any other courts where I've heard them say that they're not allowed to say the grounds for their objection, where they're not allowed to say hearsay or foundation or outside the scope or whatever the case is. That is such a simple thing, and it makes the record more clear, and it makes things more clear for, and plus then it's like, if you don't do that, which she doesn't do that, and then you make United has a great point. If you're making them go to sidebar every time they need to discuss whatever it is, then that's going to not only make things go way longer, like we know that, but it's also going to it makes things seem worse to the juror, because it's like, oh, they said objection, now they all have to go talk about it, when it could have just been like, objection, foundation. Okay, cool, now I'll lay the foundation. It could have been something very simple like that, but they are not asking for that. To me, that's such a no-brainer, especially because if I'm a judge, I'm going to want the record to be as clear as possible. And she's like, nope, denied. Next. How? Why? I don't get it. Sinbad 33, meant for 16 whole months. Love our little family. Seeing Brainy live. It's like music. I'm glad to be live. Happy 16-month anniversary. Okay, and she also denied the motion to continue, which I called that. I said that yesterday, or whatever. I said she ain't gonna, Bev ain't gonna be having that. But she did say that she won't immediately swear the jury. So at least there's that, I guess. It will probably take quite a while for them to seat this jury. Wait, doesn't this end up... Where's my handy dandy? Doesn't it end up putting us like right at the starting time that it was from the last trial too? Wasn't the starting time like... Hold on, where's my sheet? Get my sheet. Yep, because the first, oh, wow, that's so weird. That's so weird. The first day last year, day one of opening statements was April 29th. So this is actually going to be, if she's not going to impanel the jury right away, it will probably end up putting us like right around, isn't that weird? It'll be interesting to see how long this one takes compared to how long the other one took. I'm worried about that. My life is going to be stuck at my computer for all those months. Yeah, that's kind of crazy, huh? Big old full circle of life. Kind of. Whatever. Debbie Long, member for 21 whole months. What has happened to the camera guy? Too much caffeine? Are we shaking? Why are we shaking? What's happening? Okay, now we're steady. Better. Debbie Long, member 21 whole months. Love being here. Thank you all. The best ever. FKR. Thank you. Happy 21 months. That's crazy, right? Our little channel, just a growing. Did she rule on ARCA? Yeah, she's gonna make them come in for another evidentiary hearing or another voir dire next week. What's funny is that Brennan's like, well, we don't know what they were provided. Sir, I will get you the timestamps. I will get you the timestamps. It's in their report. There were 11 things. He lists them. It's on the report. What do you mean you don't know what they were provided? It's on the report. It's on the report. Somebody send Brennan timestamps. The things that he says. And she's going to... So now she's like, well, we're going to voir dire ARCA next week. So it's like, oh, hey, by the way, we're going to have, here's another $23,000 expense, and you have to get these witnesses out here with less than a week's notice. No biggie. To go over things that we've all already gone over. No biggie. And people wonder why she's being questioned so much. And I've tried really hard to give the benefit of the doubt on things, but when you look at stuff like that, it's like, really? Really? Is that what we're doing? The motion to extend the buffer zone, they said that they could, the jurors said that they could hear people outside when they were deliberating, so that one will be, I don't think she said that she was going to approve it, but that one will be approved. The defense took no position on that. Mildred, thank you for the super chat. Bev is determined to drive Karen Reed into bankruptcy. That's what it seems like. I wasn't born with Thorne said no voir dire on any Commonwealth witnesses. No, she approved that last one when they had given no information on how he was qualified to say what they were saying that he was qualified to say. And she's like, yeah, he's cool. He meets the standards. No biggie. See y'all there. Peace out. But for every defense witness, we have to go through 11 days of voir dire and a whole list of that's why it is hard not to question things. I think that at this point she is pissed at the defense and she is taking it out on them. It's wild to me. Wild to me. I don't understand how the speaking objections things, if nothing else, how is that one not a no-brainer? And then the motion to reconsider on the dog behavior specialist to give medical causation of injuries. She doesn't want to talk about that right now. She's like, we'll address that when we get to trial after Dr. Russell's testimony. This isn't about Dr. Russell. This isn't about Dr. Russell. And I get it. It's because Dr. Russell, if she testifies and says stuff, then Brennan's going to bring him in as a rebuttal witness. So I get that that's what she's saying. I understand. But it's not about Dr. Russell. It's about her ruling not being level. If you're going to rule this for one side, the ruling needs to be consistent across the board, and it's not. So it doesn't have to do with if they're going to bring him on rebuttal or not. And I guess, you know, she doesn't want to address it right now because if they don't bring him, okay, but now we're going to get to the very end of trial and we're going to have to argue this again. And it's just, when it should have just been a consistent ruling in the first place. And I don't care how many Twitter trolls try to spin this in a legal way. It's not a fair ruling. And every single attorney has said the same thing. That is not, that's not, and every single one of us was like, well, this is a no-brainer. She'll let him testify about whatever, but she's going to say no to that. All of us were like, not even paying that much attention to it because we already knew what the ruling would be because she's already made that ruling once before. And I'll be damned if she didn't just shock the bejesus right out of all of us. The false statements one from Proctor, that one is, Proctor had said something about, this was interesting in the motion actually. Proctor had said something on the stand in the last trial about how, you know, Yannetti went to the school where his sister works and was asked to leave and he refused to leave and he was there to harass Courtney Proctor and he asked if Courtney Proctor was working and all this stuff. And all of that was fake news. Like that was all a complete lie. So they wanted that kept off the record. And we know it's a fake. We know that that was a lie now because the principal himself has said, you know, it's in the motion. I can't remember. Like, I think he called like a resource officer or something and said something about how they were out there. And he's like, just in case, you know, like media gets aware of this or whatever situation happens, you know, I want everybody to know they're out there talking, whatever. And they said that like he had never approached anybody, none of that stuff. So anyway, all the stuff that Proctor said was a lie. So they wanted to keep those statements out of the trial. And Brendan says, of course, no objection from that. They're not going to bring it up or elicit that testimony. The sidebars thing is going to be interesting to see. She wants to impound those sidebars. She wants to keep as much information from the public as she can. Because the public's eyes are like, everybody watching. And she wants to keep as much of that sealed as she can. And so last time they were sealed, everybody agreed. This time, Yannetti's like, this is a new trial, ma'am. Remember, you said that this is a new trial. Yeah. So we're not just going to agree to it this time. We want those to not be sealed. Obviously, anything with the jurors, you know, that stuff would be, but we want those to not be sealed so that information doesn't get out to the public. And she's like, Brennan, is there authorization for this? So now they're trying to find out if she's allowed to, they're allowed to make that decision if there's an objection to it. The manner of death thing, there's no legal basis for that, but she'll probably approve it anyway. the whole thing he was saying about the manner of death being redacted, we've talked about this in trials before. Like when they say homicide, it does not mean like homicide in the way that a legal definition of homicide is. Homicide means that it's at the hand of another. So that doesn't mean that somebody is legally liable for the death. It just means that the death was caused by, by somebody else, the hand of another. Accident, homicide, and suicide all assign some kind of responsibility for the death. Undetermined does not. So the whole point of redacting those is to prevent the jury from mistaking any kind of responsibility being assigned to any one person. Undetermined doesn't do that. He wants undetermined because it's like, it works for the defense for them to say, like, look, even the medical examiner couldn't say that this was a homicide or an accident or anything. So he doesn't want that on there. The next one we have up is Dr. Welcher. Let me get out my thing. I have that one somewhere. Here it is. Dr. Welcher. Where's the first one? There's Garrett Wing. Here's Dr. Welcher. Let's see. So there's a biomechanical engineer named Dr. Welcher, and the defense wants to exclude or limit his testimony or have a voir dire. I haven't watched the documentary either. I haven't had time. Plus, I saw that there are two people that I saw in there who are two of the least credible people that I've ever seen in my life. And so I automatically am like, oh, never mind. So, so let's see. So the, testing performed by Dr. Welcher is widely utilized and generally accepted. So I guess Dr. Welcher's opinion that the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right taillight of the Lexus. So basically, he's saying that he's wanting to give the opinion, or he's given the opinion in his report, that he thinks that the injuries to John's arm line up with the geometry and orientation of the right taillight. So he's like the anti-Crash Daddy. He's like Crash Daddy's arch nemesis, coming in to say the exact opposite. So the defense is apparently challenging whether Dr. Welcher is qualified to testify to medical causation of the injuries, because remember, Crash Daddy wasn't allowed to. And he says, Brandon says that biomechanics are qualified to determine what injury causation forces are in general and can tell how a hypothetical person's body will respond to those forces, but are not qualified to render medical opinions regarding the precise cause of a specific injury. They haven't unmuted us yet.
Before we begin,
Oh gosh.
realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify. And we'll give you until then to comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week, unless you made arrangements.
No, I didn't make arrangements. I just want to make sure that we're very well defined on what issue is before the court that would justify a voir dire. I just want to make sure, I don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for a voir dire.
Okay. All right. So what I need you to do beforehand is make sure that all Rule 14 discovery is complied with. And if it is, then we'll see. Okay?
So it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having...
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah, understood.
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
My discovery motion extends beyond Rule 14, and the reason why is it includes the communications between the parties, which is necessary to understand. So it's not simply Rule 14. We have a court-ordered discovery motion that we filed that includes the request for this information to show bias, and I don't want that to be overlooked.
All right, so talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell me before we start the trial where you stand with that. Okay?
Yes, Your Honor.
And what you still think you need, Mr. Brennan.
I'll inform the court.
Okay.
And I'm pleased to speak with Mr. Brennan at Your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
All right.
May it please the court. In my presentation today with regard to Dr. Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
She's so rude.
In
Oh
my
gosh, she's so
presentation
rude.
today, Your Honor, I'm going to, just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140-slide presentation,
Okay.
what the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025, from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance or any of the Daubert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the Daubert factors. So that is the
true.
jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with...
Hold on real quick. I just got a notice that Brennan has now added Karen's defense team as potential witnesses for the trial.
Case of Canton, the SJC's decision of 2000. And I am going to provide 4 parts of Canton. Number 1, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf, and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said, and it's not my pejorative, that's the ipsi dixit comes right and is used in case of Canton. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140-slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about 2 things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canton. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area, and the Dalbert Lanigan analysis is referred to as the hard science. So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the decedent. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, "There is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused," and caused is italics in the opinion, "her to suffer from MCS. This was an error." They went on, quote, "Because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion." In the concurring opinion of Justice Greene, he added an important point. I quote, "Further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science." The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Canavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks. And that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, "At trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, etc., etc." Last sentence. "Such discovery is essential to an effective cross-examination and therefore to a fair trial." And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is quote, essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation, and this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintala. We've basically cited it for the proposition of qualifications, but substantively we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. Okay. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintala was, listen, this person was a paint engineer at his company and he had a lot of experience in that, but what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintala. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher in his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, "Expert testimony also may be based on or informed by the results of experimentation." Skipping. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Giuliani conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Dalbert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Giuliani's methodology or experience. Instead, it appears that Giuliani designed these experiments on his own without any guidance. Reading down below, quote, Giuliani's experiments also did not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court.
I'm a big fan of Alessi's organizational skills. His, I'll put this at 1.25 because I'm talking. I'm a big fan of his organizational skills, his color coordinated highlighters and all that stuff in his binder, his clear argument style, and his vocabulary. Bro's got a vocabulary. I love it. It's impressive.
Court said Giuliani did not repeat or validate any of his experiments is also significant. There is zero in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. He continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important.
No, too nerdy. You can never be too nerdy.
Do is they apply Newton's second law of physics.
Look, Alessi, you can never be too nerdy. Alessi, you go ahead.
Force net equals mass times acceleration. That's the mathematical formula. Because biomechanical engineers want to know what's the force being applied, and when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this cases where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it as part of his opinion.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that. But the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2. 2A Romanets 3 and 4. Romanet 3, 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C, testimony of Jen McCabe. That's his heading. Karen Reed stated to her, etc., etc. In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe's, or frankly anybody's testimony? It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1:1, 42622 Julie McCabe, 42622 state grand jury page, etc., grand jury minutes. It's testimony. It's testimony of lay witnesses.
Yeah.
Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition. He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I've pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist, he's not a hydrogeologist, he's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner, he's becoming a lead investigator, he's becoming a cell phone data forensics expert, he is also, once again, talking about testimony of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, etc., and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
I wouldn't be introducing evidence of frozen ground through Dr. Welch. Is there other parts of the
cause of death?
He would not be offering the cause of death. I think the spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. The hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go through each one.
Sure.
Thank you. So 4A, he says and this is what he means by totality of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data? That's a data forensics. We had obviously moments I'm sure Your Honor may wish to not remember, but with regard to Mr. Green, etc., we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, arm, forearm lacerations 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E. I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground we're not going to bring in. The air temperature is important because it talks about the density of the strength of the taillight. That's part of the conclusion. So there'll be evidence before he testifies about the weather we expect. Okay. And he can rely on that to talk about how that might affect the taillight. But the frozen ground, we agree, that would not come in through Dr. Welcher.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
E.
Did y'all catch that? He said that they're going to have testimony about, this is something we've talked about before, but it wasn't in the last trial. They're going to have testimony about the air temperature and how that can affect the tail light. I'm assuming because remember we talked about like if it's like super cold outside, it would make the polycarbonate more like brittle and easier to crack. It's still not easy to crack, but easier to crack. So I'm assuming that's what they're going to bring in.
Hat line and fracture location.
Although, to be clear, I still don't see, no matter how much it makes it a little bit, easier to crack, I still don't understand how it could possibly crack on a human arm and do no damage to the arm other than scratches, but that's just me.
Consistent with fall and posterior head strike. Extraordinary. Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with regard to F. This is the wayward, undocumented experiment that Dr. Welcher conducted. F, Romanet 2 should be...
When they say wayward, undocumented experiment, I think of Murdoch with the guy that was throwing his phone on the couch. Anyway, continue.
Excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, etc., etc. That experiment I've covered in what the case law requires for him to show. There is zero support for this experiment. I went through in Rentola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area. But you've got to show all of these things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of concern? Every single deficiency in Rentola is extant with Dr. Welcher. His experiment must be excluded if Rentola is to have any meaning in Massachusetts jurisprudence. G, Julie Nagel and Ford occupants. Again, what does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128 and early morning of 129. H, Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But
yeah, this is the problem. So the biomechanical engineer should be there to do biomechanical engineer shit. They should not be there to talk about testimony from other, from Commonwealth witnesses. So to have that in your report and to have that as part of your reasoning, that doesn't make any sense. Now, when you look at at the other side of this, the biomechanical engineer, Dr. Rentschler, when he talks about the things that he used for his report, that's this is almost like he's trying to go beyond the scope of what he's there to do. And, he's moonlighting as a detective, and that's not the job of a biomechanical engineer. They're there to give expert opinion on experty things. They're not there to, consider the testimony from other witnesses. So one of the things that I loved so much about Crash Daddy, Dr. Rentschler, was that his stuff, when Lally was going over all that stuff with Dr. Rentschler and Dr. Wolf, when Lally was going over all this stuff, well, did you know this? Did you know that she said, did I hit him or that I hit him or what? And they're like, no, because that doesn't that doesn't matter to the experiments and the testing that we're doing. What she says or what other witnesses say have zero impact on physics and science and biomechanical engineer shit and what they're doing and what they're there to do. It was very factual and not based on one side or the other's testimony. And I think that that's the issue that I have with this one. I am all for bring in somebody else with a different opinion, let the jury hear everything and make up their own mind. I am all for that. But I also don't think that it should be crossing those lines of bringing in testimony about this kind of stuff. If you're gonna come tell me, a layperson, about biomechanical engineer stuff, stick to the biomechanical engineer stuff.
yet he's proposing to testify and state that. What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 indicated John O'Keefe did not enter 34 Fairview. Even more egregious than H. Romanet I.
Yeah, that shouldn't be in there.
So, with regard to Dr. Welcher, I have...
That's the big thing. If you're getting... A biomechanical engineer should not need testimony about who saw what or what they think, they saw in the dark, in the snow, whatever. Those are things like that. Stick to the science stuff. And if you are being given information that is supporting this one theory, then, your conclusions can be based on that. And I just think it can skew it. I would rather just stick to the science stuff and let me hear it.
again, genuinely tried to assist the court with regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds, based upon his own stated parameters. And with regard to the case law about not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury. And the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear as I have recited. With regard to this experiment, prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rintala talks about. Both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient to, and based on physics, are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it, and the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted. But there are different demonstrations that we do expect. The demonstration at Meadows Road, which clearly depicts that the cars didn't contact with the taillight, we want to produce. The drop test, similar to ARCA's test, we intend to offer that. But as far as the extraneous commentary, no, that's not intended to be, it's not proper, and we wouldn't even try to produce it.
Do you intend to use all 140 or however many?
No, we were comprehensive in the production to the defense so they could see the data points, how it was produced. And so we've included, you see many of the slides is the cameras showing the different data downloads. There's only a fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welcher's arm, and also we would want to show the ways, locations based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on that?
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
Right, so this will have to be provided to you prior to its done.
Thank you. And do we have a date so we can adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
You can have them by Monday.
Okay.
And Your Honor, if we have an issue, still, can we submit something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to get the basics.
Sure, so you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond, and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court, as the gatekeeper, a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard, that's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to, and we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are, but I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay. Mr. Brennan.
Ugh.
I'm particularly disappointed that Mr. or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has. But
Oh,
the case
jeez.
study in that is the
Ah.
I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. ARCA and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher, cannot come in and talk about the opinions or testimony of witnesses as it relates to their statement. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. The testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather, if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles in his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, that they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon.
Okay, first of all, Brennan, he didn't say it was a cool idea. He said it was really cool. Don't be misquoting our crash daddies, okay? Number 1. Number 2, he used evidence that was handed to him to see if this was another potential possibility. The way that the glass was cracked, they said didn't make sense for it to be an arm. So he did some testing to see, well, there was broken glass that was found. So maybe if the cup had been thrown at it, the base of the cup was hard enough to break it. That's why they did the cannon. Don't be disrespecting our crash daddies. I would take crash daddies over Hank any day.
Cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video. Or some
I agree with
specs on
that.
it.
Look,
or maybe some details on how it actually operated. See, these are the
look, I think that's the only thing I've ever agreed with Brendan on. Somebody timestamp this. This is the only time. It may never happen again. That's the only thing I've ever agreed with Brendan on. It would be really cool to see pictures and videos of the cannon. That's it. That's the only thing I agree.
the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions. He shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion based on just trust me. And so when you look at the production.
Coming from the king of just trust me, bro. Really? Really? I wonder if he knows how hypocritical he is, or if he doesn't care. Like, you know how like some people have like zero self-aware? I wonder if he knows how hypocritical he is. He is minimizing what ARCA did. Shut up, Brennan.
By Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics
Bring
and
the
science.
cannon.
And it also details medicine. He's not a medical doctor. He's not diagnosing an injury, but it includes all of those arts. Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Lisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it. They don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart.
Yeah.
No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on a study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective, they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welch's opinion is different. It's the same engineering, it's the same science, it's the same concept, it's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Alisi is insisting on are excused, but if they don't like the opinion, somehow should it be excluded. They're really polar opposites when you think about the perspective and the opinions they give it. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis.
See, that's the exact, Brennan, that's the exact point I was just making. That argument that he just made is the same thing that has happened with every single expert that Brennan has tried to keep out for the defense. Every single one. When he doesn't like the opinion, all of a sudden the standards are changed. But when it's his expert, he's like, here's this really long CV, and just ignore that I didn't give you anything else. He changes this. Oh, Brennan. You're going to give me wrinkles. I feel like this is, by the end of this trial, I'm going to need Botox because I'm going to have the angry lines right here. Brennan, don't do that to me. I'm too young.
And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until. We have all that evidence, and as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does. The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation he actually shows not only the nudging and the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows, with great continuity, the height, location of that broken taillight, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered at evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements, and we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions. And there will be no trial by ambush. Now, we will be studious in getting that information to the defense. We would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well, and if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery. Okay. Sure.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it. On a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then, so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we contest, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration, and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions, which the court could take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Daubert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries, I understand what Dr. Welcher did. The question is not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Daubert factors. So, in conclusion, Your Honor, I go back to Rintala, I go back to Meeks, I go back to Case of Caravan. The Commonwealth has not today, not before, this is their 4th time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position. This equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop those opinions from going to the jury, to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay. Go ahead, I'll hear a quick response.
Get on up there. After Alessi just called you
Regardless, I
out.
know Attorney Alessi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements. This isn't the first time that Mr. Alessi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence.
Shut up.
There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it, because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alessi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful. Attorney Alessi is joining the fray, and that is all part of the strategy here. Now, if you look at page 13 and 14 of Dr. Welch's report, perhaps that was missed in the review, there are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
All right, thank you.
Okay, if you're going to come after Alessi actually is the one who said when he was going through all that he was going to give you the benefit of the doubt and assume that it was the court reporter who got it wrong because he went back and looked at the transcripts. He actually said he was going to give you the benefit of the doubt. So saying that, oh, I went back and looked at the transcripts and they were wrong. Yeah, bruh. That's what he freaking said. I can't stand him.
So we're going to move on to try and get some motions in quickly.
I don't like
motion regarding the chalks. Is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations in chalks prior to using?
No objection.
Okay, thank you. 583. Is there an objection to the Commonwealth's motion in limine to allow the expert Celebrite demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. Is this something that can be done quickly, or is this something you need more time on?
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
I can do it unless, if you tell me what
No, let's see what we can get before the luncheon break. The paper number 585, it's the Commonwealth's number 11. Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases. So is there an objection from the defense on that? If there is, I'll hear quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case. In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant. We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear, based on that and other testimony, that he was in the course of attempting to end the relationship with Miss Reed. And so his statements, especially over the course of the day of this incident.
All right, so what's the time frame? It's so over the course of the day. I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate this?
As far as his messages, I will
or
look.
the statements or the evidence that you're trying to put in under this doctrine.
His niece would testify, as she did in the last trial, about the tumult in the relationship.
Okay.
And we'd introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Okay.
And there would be nothing different from the last trial other than the fact that we are not going to pursue the Aruba information. So it has actually a narrower time window than before.
Okay. All right, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements. That in some cases, they are multiple hearsay statements, or potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Miss Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
Right,
with.
that's what we were talking about, the bins, quals, those points.
Correct,
That need to be made.
and that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had a what was considered and what was testified to in the first trial is a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening, and they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. Couch it in whatever terms
he wants, but that's really what it is. These witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence, that was imparted, or those specific conversations were imparted to Miss Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Miss Reed at both C.F. McCarthy that night, as well as at the waterfall that night, show the two of them getting along, completely inconsistent with two people who were talking about breaking.
What happened?
Up. John O'Keefe wanting to dump her and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job, had her own house. She was not dependent upon John for anything, not for money, not for room and board, nothing. They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one. And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts that Karen Reed would kill John O'Keefe rather than simply break up with him or allow him to break up with her, and they both go on their own way. It's absurd. And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have, establishes exactly the opposite. They were a loving couple, out one evening, having drinks with friends, in a good mood, and happy with one another. We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, "A murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly," the court's words, not mine, "and most importantly, would be likely to respond to it." The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it, and act on it in a violent way that would take someone's life, but at the same time, they're stuck with the very clear fact that if in fact that's true, and it was imparted to her that he was unhappy in the relationship, she never acted on it, not once. And the moment that we do have frozen in time that we can go look back on, is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect. I suspect that it's more that they would like to have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her.
That's what I said earlier.
It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt. We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by Ms. Voss on June 20th, 2023, about that night, or the day before, and she says, I was temporarily frustrated, it wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep. Now, in addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so we have statements from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive. Without reading them, because it's unnecessary, there is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time, moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
If I could just correct the record very quickly. Sure. If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the every time he stands up, he says, "I've read the I wasn't there. I read the transcripts." We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
I'm sorry, I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done. This was during the time after 5:07, after the SUV leaves, we see One Meadows, and Jen McCabe and Carrie Roberts get together, and as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being, some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning, dealing with, did you feed the kids donuts? And yeah, I did. You know I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment, getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay.
Before accusing somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, attorney...
Excuse me? Of all people to say that?
Jackson was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22. Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1, totally contrary to what you just heard. Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband. Not my words.
All right, so we're going to break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this. Hold on, both sides. I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions. Leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2.
Your Honor, if I could say one more thing. As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave. Let's leave it.
Wasn't that fun? I think we all do after this. I'm gonna be honest. I think we all do. Wow, that's all I can say. Yeah, same. Same. So here's the thing. Let me mute this because if it comes back and they're like all of a sudden loud, I'm not going to know it because I'm taking my headphones off for a few minutes. If they try to bring this in, then it's just going to make things, it's going to make things go longer. so Brennan is showing us right now that he's planning on using, he's not going to be introducing actual evidence. He's going to be introducing interviews and whatnot. This is like the most Gossip Girl prosecution I've ever seen, but that is apparently what we're going with. So, okay. The text from that day, when you actually read the full text exhibit, the difference in what Brennan is saying and what Lally said, what Lally introduced and all that stuff, the difference in the cherry picking of those and then the full context of the text, it's two very different things. It's two very different things. We're coming back at 2. They're going to be back at 2. Here, I'll put it in chat. Court is on recess until 2 p.m. Eastern. Pin message. So if you read the full text from that day, it paints a very different picture. And I think that that's something that a lot of people have not realized. The text from that day, like she's saying that she's not going to come. And, there's this part where she's telling him, that she's, I thought we were out of daylight savings time. I thought we were back in standard time. Didn't daylight savings time end like 2 weeks ago? Is it EDT now? I thought it was back to EST. Whatever, Eastern. It's Eastern. So the texts from that day are like, there's a lot of text where he is asking her to come to the bar. He wants her to come there. She had said something about how she wasn't going to. She said some stuff to him about, how amazing he is about, what a good job he's doing and stuff. And he's talking about how he hates that he always has to be the bad guy and all this stuff. But like, she's talking about getting a plumber to come look at something in her house, and he's mad that, that she's having somebody come look at it instead of, he's like, I could come fix it. And it's a very different conversation than what it was painted to be. And he's even telling her, he's like, are you gonna come or not? Because I'm gonna rely on you for a ride home, or however, whatever he said it. That's not verbatim, but however he said it. But the thing is, the way that those texts are presented makes it sound like he was like breaking up with her, and then she just all of a sudden showed up, and that's not what it was at all. He literally was, asking her like to come, and, wanted her to spend the weekend and stuff like that. So, I think that a lot of people, because they only showed some of those, a lot of people haven't seen all of those texts. And I think that gets confused by some people. So if they try to bring in some of those texts, now it's going to extend the trial, because now they're going to have to the defense is going to have to show the full context of everything. I say extend the trial. I mean, everything they're doing is going to end up extending. This is going to be the trial that never ends. But it's going to, I'm assuming, probably make it to where they have to bring in the entire thing to give context, just to show that all this is wrong. It is interesting too to see the attorneys getting so frustrated with each other, especially because Brennan is a nightmare. He is a nightmare. And Alessi is getting sick of him. I've been sick of him. That ain't no surprise. But Alessi's getting sick of him. Jackson is obviously mad. But see, Brendan gets up there and he does all the, like, he makes all these attacks on, and Brendan even does it in his motions. He, makes all these, like, takes these little digs and stuff. So it like, you can only do that for so long before you start really pissing people off. So Bev saying, like, the personal attacks should be left out of this. Well, yeah, but they haven't been. And that's the problem, because there have been nonstop attacks from him. Like, the way that he said something, like, he basically accused Yannetti of lying when Yannetti was like, that was an in-court thing, talking about the Zoom, and he was like, that was an in-court, hearing, and he was like, oh, well, Court TV wasn't in the courtroom. Stuff like that. Like, you can't expect to keep nagging and poking people and then be surprised when they finally get sick of you lying and start behaving accordingly. This is like nothing I've seen. It's like nothing I've seen. He has changed. He wasn't so dramatic. He's so theatrical. And it annoys the bejesus out of me, because his theatrics are not, there is a time for theatrics in the courtroom. I am all for theatrics when, when they're warranted. But when you are theatrical for the sole purpose of trying to, it's almost like he's like, well, if I act outraged enough by this, then people will believe it's the truth, or whatever. It's just, he is, and I've said this before, he's prosecuting this like a defense attorney, and that's not his job in this case. I know that he's used to being a defense attorney, but he's not a defense attorney. He's the prosecution in this case. He's the Commonwealth, and they are held to a different standard. They are held to a higher standard, and he is not meeting that standard. He is acting like a smarmy, like, ugh, I can't stand him. I cannot stand him. I would give anything to have a good judge, good, good fair judge, good fair prosecutors. And Karen's got a great defense team, but I would love to see an even playing field for everything, so that we can get, get the truth, or as close as we can get to the truth anyway, without all of the theatrical crap. He needs a good stifle. He needs a good stifling. He said stifle. Stifle. I'm not usually one to make fun of people saying words wrong, because, like, I always, you remember, like, back in school, like, when you had to read out loud in classroom, like, that's like when my anxiety started as a child. But like, did you ever have like that fear that you were going to say something wrong? And I remember I had heard at some point where someone said something about if never make fun of somebody for saying a word wrong, because it means that they learned it from reading, and reading is good, or whatever. How it sounded probably much more poetic than I'm able to say. But I remember hearing that, and I was like, oh yeah, that makes a lot of sense. But how are you going to be a whole attorney and not know the word stifle? Okay, I just, okay, that's where we're at. He would say he's just using a gentle, it's a gentle nudge. Remember, they used to not even admit that the SUV hit John's car. They used to deny that even happened. Now they're saying it was a gentle nudge. Just a gentle nudge. You know how some lawyers leave the courtroom and go have a beer together? I bet that is not the case here. These guys really just, I don't blame them. I feel like in the courtroom, you can see a lot of times when there is that, it's kind of like basketball players or football, like you might be enemies on the court, but then after the game's over, you go and high five and like swap jerseys and shit. So I feel like this is kind of one of those things where it's like, or not this is, but like courtrooms, are usually like that, where it's like, you're opposing teams while it's, court's in session, but afterwards you're cool. I don't think that's the case here. I think you're right. I don't think that, I think that too many things have been made personal, and you can't make some of these things personal. Like Brennan has taken some low blows, and they've had big consequences. And I think that I wouldn't be cool. But what do I know? I have zero respect for him as a lawyer. He's slimy and childish. I expect better from the state. Me too. Me too. And it bothers me that we can't get better from them. I don't like it. I don't like it. A love tap, if you will. Brennan is why people hate lawyers. I don't disagree with that. I think that I don't disagree with that. They can't respect Brennan because he literally gets up there and lies about them. That's the difference. I think that, yeah, and the things that he says are like, these are things that have like consequences, and he just doesn't seem to have any kind of concern for that. Breezy, thank you for the super chat. Thank you. There is not enough White Claw and Jameson and ginger for me to want to drink with anyone from the Commonwealth. I need my daily donut. Thank you so much. I appreciate it. Thank you. Yeah, I don't think I would either. If you had to pick, okay, let's say you're going on a cross-country ride. Let's do a poll. We're gonna do a poll. Cross-country ride. And you have to pick one. You have to pick one of these. I'm putting it up now. Pick one for a cross-country trip. Let's do 4A. How long does it take to drive from one end of the country to the other? Let's just say 3 days. For a 3-day cross-country trip. Okay, so you have to pick between Brennan, Auntie Bev, Lally, we need one more. Who could be our fourth? No, Crash Daddy's not an option because that would be an overwhelming, everybody would want Crash Daddy. We've got Brennan, Auntie Bev, Lally. One more. We need one more. Proctor. We'll do Proctor and Buchanan. Like as a duo. Could you imagine them together? All right, start poll. And Lally would be like, what, if anything, is for dinner? Who, if anyone, is going to pull over? And Brennan would be like, dare I say, you are, oh, he would be like the one that, like, if you're speeding, he would be like total tattletale on you, you know, like, I know that some people may not care about the laws and the speeding laws, but I do. He would be one of those. Ugh, he would be awful. I feel like you'd have to just listen to a ton of locker room talk if you're listening, if you have Buchanan and Proctor with you. That's no fun either. Like, they're all really bad choices. Mildred, thank you for the super chat. TB needs to stop making faces. He draws Bev's ire. He has cost Carrie thousands with his antics. I can't fix my face either. I have to make a conscious effort when I'm in the courtroom to fix my face because it can have consequences. I have to, like, really focus. Chloe. Oh, it would be Chloe hands down if Chloe was one of the options. Breezy, Proctor, and Buchanan will be drunk too. Can't get in the car with them. They might lose it. It's true. They're going to lose their guns, their ID, their jobs. Too soon? Sorry. It would be impossible for me to keep my expressions in check in this courtroom. Yeah. I would have problems with it too. I know I would. Because these things are really frustrating for me. I just hired Trial Daddy. We can go on special ops to kick Bev's butt. I will confirm nor deny said operation. You know I love special ops. Oh, actually, I got my it's Chat Daddy's, but it's got the. I'm ready for special ops mission right now. Marie Moss, our official statistician. Meant for 18 whole months. Glad I'm behind a computer screen, just saying. Marie Moss can't fix her face either. Something in the water around these 13 jurors. We just can't fix our faces. And that's okay. That's okay. And then when I try to fix my face, then it comes out as even less fixed. Because then I'm like, I picked anti-beverage. I would just keep her unconscious with White Claws the whole time. Could work. It's because we still can't say fresh. It's the other F word we're not allowed to say on this channel. Fresh. You can't say fresh. Can't say fresh. I just hit the button and didn't mean to. I would never get in the car with the one I accidentally hit. Who did you put in the poll? Oh, my late hubby was in special forces in the Air Force. Oh, that's cool. Chat Daddy's special forces for Army. He was Green Beret. Very cool. Some of those stories are really cool. Brandon, you put Brandon, he's the worst. He would be the last on my list. He would be the last on my list. Who would be my choice? Probably... Not Brennan. Definitely not Brennan. Brennan's only at 3% right now. Everybody dislikes Brennan the most. I don't know who my choice would be. It's a hard poll. I don't know why I do hard polls. Nurse for God, get to 5 memberships. Thank you so much, Nurse for God. Thank you. Maybe not Brennan. It's like you can't pick a best, so you have to pick the not worst. I feel like Proctor and Buchanan would just be obnoxious, so they're out. So it'll be between Lally and Bev. Maybe Bev. Maybe we could bond over something. Something. I'm sure there's something we could bond over. Right? This poll sucks, Brandy. It's really hard. That's really hard to pick from those, isn't it? Chat Daddy's bonding. I'll do it with Chat Daddies. Lally will put you to sleep. That's true. If you're driving, you definitely couldn't do Lally because... Yeah, you couldn't do Lally. Yeah, we could bond over the beach. Doesn't she have a seaside cottage? But how long can you actually talk about that before you have to move on to other things? Proctor, just because the others raise my blood pressure. One of my sons is a combat engineer for the DoD. He also served in the Army for 10 years. Oh, that's cool. Who would you pick from the defense team? My instinct is to say Alessi because y'all know that like organization and like color coordinated charts and stuff like that's my love language. And Alessi speaks my love language with his overly organized charts and color coordinated highlighters and pages and just the way that he the way that he, like, I feel like it would have to be him. I feel like Jackson could keep you more entertained because he could tell you, like, he's very charismatic. He could tell you stories. I feel like Yannetti is very personable. And then Liza, of course, is, you know, super smart and has great hair. I think it would have, for me, it would have to be Alessi because I love his organization. So, the binders, he had me at his color coordinated binder, y'all. He really did. So yeah, the cottage sounds great, Bev, but I gotta ask, what the hell? That would literally be my car, like, because you can only talk about the seaside cottage for so long before you have to just be like, bro, what are you doing up there? All right, I'm gonna end this poll. Let's see. Where's the results? There we go. Okay, so Brennan only got 3%. Proctor and Buchanan are the next lowest with 16%. Auntie Bev is at 38%, and Lally is at 4%. So most of you would do a trip with Lally. Did any of you think that you would be saying last year when we were going through all this, did any of you think that you would pick Lally as your road dog in any poll ever? Who, if anyone, would have actually thought? None of us. None of us. I think only one person, no, 3 people voted for Brennan. Hank Brennan. I choose Brennan if I could leave him at the world's largest ball of yarn. Brennan would just make me drive my car off of a cliff. No, let me behave. I'm not a fan. I am trying to be, I would love in this moment to be kind and loving and as graceful as Brennan let us know that he is in the last hearing. But he is not, I'm not a fan. I am not a fan. I am not a fan. Can I take my vote off for Brennan? It was a mistake, and I would have picked What If Anything out of our choices. Girl, it was only 2 because I didn't mean to stress that, please. Yeah, okay, so only 2 of you. And the other 2 were probably also accidents. Or either y'all would pick him to leave him at a rest stop or the ball of yarn. He is not displaying any redeemable qualities. And that is a good way, that is a much nicer way of putting things, because I am sure that he has lovely qualities. Somewhere that he exhibits for somebody at some point. I just have not seen them in this case, and it makes it hard for me. The way that he does things is not how I like to see things done, and it makes it difficult for me to not be snarky with him. I don't like the way he moves. I think that he is not showing characteristics of integrity, and he is not behaving how a prosecutor should. and I hold prosecutors to a high standard, and I don't like the way he's doing things. So it is hard for me to give him all of the grace that he lets us know that he has given. Linda, thank you for the super chat. You and Bev can bond over a biscuit. Taste the biscuit. Taste the goodness of the biscuit. It's true. Chrissy Bacon, remember for 20 whole months I will behave, but it's hard to with Brennan. It is, isn't it? It is. I'm trying, y'all. He makes it so hard, though. He makes it really hard. I want to exude the kindness. I want to exude the grace that he told us that he exudes, but I just can't. I'm going to work on that. I'm going to work on that. I'm going to try to. We shouldn't have complained so much about Lally, right? Only we knew then. I do think, though, that he's made it very clear that this is going to be a very different trial. He is going to try to prosecute this on TV and Twitter shit. And, you know, he's going to try to get the jury to hate Karen Reed. So that then they're looking at all of the evidence with I hate Karen Reed colored glasses. What are your thoughts on Yannetti saying that the feds took his file? I had not heard that before, and I am glad that they said that, because I feel like that does clear up a lot of things that have been implied from the Commonwealth for so long. Because the way that they have made it, that has never been made clear. So the way that the Commonwealth has implied this entire time, they've done so much to, like, you know, imply that the defense just handed over whatever they wanted the feds to have. Like, here, look at this part. And I think that now there is some clarity on how the feds got what they got. And then, of course, the feds decided what they, you know, what they thought was relevant. Nothing comes down to real evidence of if she did it or not, just confusion for the jury. Here's the thing, though. Do you think that, and y'all tell me in chat what you think, and everybody be respectful of each other's opinions. Do you think that if this next trial, if they have let's say that the Commonwealth crash daddies come in and they give an explanation that you think makes sense on how it could have happened, or how those injuries could have come from, you know, if they're able to explain it in a way that you're like, okay, that's a possibility. Do you think that it would be enough for you to change your vote? Do you think there would be enough to convict? Because I think my issue at this point, one of the things from the very beginning that I've said is that the injuries and the damage to the car have not lined up for me. And also, there are so many issues and sketchy situations with the witnesses and the investigation and all of these other things. So, do you think that if the Commonwealth's version of Crash Daddies, if their experts come in and can give an example or an explanation for how everything happened, do you think that that would be enough to either convict her or for you personally to change, your opinion on if you think she's guilty or not? Because at this point, I think that there's so much crap that has happened that there's so many issues with the investigation. There's so much stuff that has happened. There's so many like butt dials and, phones going on to military bases and, police statements that where either the police were wrong or the witnesses were wrong or whatever, the disaster of Pirouette Paul. There's so much stuff that has happened at this point that I see so much reasonable doubt. And I don't think that if they're able to show how it happened, I mean, I would have to cross that bridge when I get there, but I don't know that I don't think that it could change my mind at this point because there are so many other issues too. So it's like, in order to say guilty beyond a reasonable doubt, that means that it's the only reasonable thing that could have happened. And because there have been so many things that have happened in this case that don't make sense, I feel like it's not the only reasonable thing that could have happened. And you can't convict somebody on one possible thing that could have happened. It has to be beyond a reasonable doubt. So I think that if their expert came in, it still would not, if their expert came in and was able to say like, oh, this is how it happened. We didn't build a cannon because we're not cool like that. But here's our explanations and our testing, and they were able to say, this is what we found. I think that it could, if they're able to like really show that, I mean, it could open me up to that being a possibility, but you can't convict on a possibility. So it would still have to be a not guilty for me at this point. So, or even at that point. So I don't know. I just don't know how you get past all of the extra stuff that has created and shown reasonable doubt in this case. I don't know. I mean, look, I've always said I am always open to hearing everything. I will never have a closed mind. Except for about Brennan being the one to go on the car trip with me. My mind is closed on that. That's a no-go for me. That's a no for me. But other than that, I always have an open mind. I'm always willing to hear all sides. But I also know that, and I like to present all sides. Like when I had Dr. Kinsey, I'm like, Dr. Kinsey didn't think that it was, it didn't look like dog injuries to him on the arm. But he also said he doesn't think that obviously Trooper Paul's explanation of what happened didn't add up. I like bringing people on that have different opinions. And I think it's a good reminder that it doesn't have to be one or the other. It has to be the one or that or something else. You don't have to pick one or the other. You have to fully buy into the Commonwealth's theory or it's not guilty. And I think that's important. And I like to hear different opinions. I like to hear different perspectives on things. I like to hear why people think certain things. And I think it's important. It may not change my opinion on something. It may change my opinion on something. It may maybe not change my opinion, but at least I'll understand more your perspective, whatever it is. I like hearing things, and I'm very open to all the different things. But at this point, because there has been so much, and there still continues to be so much, it's hard for me to think that this would be possible to get to a guilty verdict. Because, like I said, you can't convict on a possibility. It has to be beyond reasonable doubt. I was shocked when I listened to the juror say that the jury didn't believe the crash daddies because of how they were represented. I guess I just knew that they would. I thought the same thing. But again, Jackson, that was their point when they argued this. Them not being able to say where they hired them from or where they found them or how they got involved in this case, that is going to be the big issue with the jurors thinking that, and Bev's like, well, I told them not to speculate. Yeah, but they're going to. Saying don't speculate. Like, oh, we can't tell you where these super secret, people came from. We can't tell you. We can't give you any information on where they came from. Shh, don't say it, but don't speculate. Really? And you expect them to not speculate? Of course they're going to speculate. So... anyone would look when their front yard was lit up. That part has always, been weird to me. My thing is there are a lot of these weird things that could be explained away. If it were one weird thing or two weird things or three weird things. There are always going to be weird things that you just can't quite explain in a trial, or you can't, or you can explain it away with some explanation. But when it gets past the point of you have to explain so many things, that's not how a prosecution should be. So I just think that that's where the difference lies for me. I really hope the defense starts and ends by explaining what reasonable doubt is to the jury. I've said this before. I think that the last trial ended up being, there was a shift of the burden of proof last time. And I think that it became the jury either, even though they're not supposed to, even though it's in their instructions, they're not supposed to. I understand it can be kind of human nature because we've seen this, social media is often a good gauge at where or how jurors will see things. And think about, on social media, it became very much like, if you said that you thought that Karen Read was not guilty, that became like you think that he got beat up that's not what I said. I think she's not guilty. I don't know what happened, and I'm not going to pretend like I know. But that same mentality of, if you say she's not guilty, then all of a sudden people think that means you either accept this theory wholly or you accept this theory as a whole. And it doesn't leave any room for all of those of us who are like, I'm not here to solve it. I'm just here to tell you if I think she's guilty or not. That's where I'm at. I'm not saying that I buy either fully. That's not my job. I'm looking at what's being presented and seeing if I think that the prosecution has been able to prove their case, and they haven't. So I think when people hear you say not guilty, and then they automatically are like, oh, then you think that Colin did it, and they drug him outside and they did this and this and this. I think that that's kind of representative of what the jurors may have felt too. Like, if you don't believe the prosecution, then you have to believe the defense. And I think that that shift of the burden of proof was detrimental in the last trial. So I hope that this one is more focused on what it actually means to have reasonable doubt and what they actually need to be considering for all of this. They're supposed to be back at 2, so they're supposed to be back in 15 minutes. Who stands with their arms outstretched anyway? I know when I got my drink, I hold it out here. It's going to be funny to watch Brandy Churchill's reaction to Crash Daddy now that she has a Chat Daddy. I'm just going to unplug his Wi-Fi that day. I'm just joking. Nobody can compare to Chat Daddy. Jury needs to be told that their job is not to solve the case. I think that it's very important. I think that if I were doing the closings, I would make a big deal about what it is that they're actually going back there to deliberate. What it is that they actually need to, why they actually need to, what they need to consider and what they're actually back there to do. Because if you just go on reasonable doubt in this case, then it's an easy not guilty. Let me rephrase. If you go on reasonable doubt in this case, it's an easy not guilty if you're going into this with the presumption of innocence, which is what you're supposed to do. If you go in with the presumption of guilt, then that's not constitutional. That's not what you're supposed to be doing. That's what I know a lot of people do. I'm not saying jurors, I'm just saying people in general. So that's a very different situation. I can't tell you how many times people have said, well, you know, they'll see some kind of piece of evidence from the defense. They'll be like, that doesn't prove she's innocent. She doesn't have to prove she's innocent. The Commonwealth has to prove she's guilty. Could you imagine being accused of something and the standard is for you to have to prove you didn't do it? People could be accusing anybody of anything, and then you have to prove that you didn't do it. That's not the standard. That's not constitutional. Why do you think John's dad is on the defense witness list? He was last time too. They didn't call him, but he was on the list last time too. The piece of glass in his nose makes me wonder if she did hit him somehow, but there's way too much reasonable doubt to find her guilty of anything. Okay, so, but think about that. There's nothing saying that. Now, if he had, if he had a piece of taillight in his nose, okay. But she said that he had like a little piece of glass in his nose. There was no broken glass where his head was. Like, so if she had said, I picked out a piece of taillight out of his nose, then I could see, like, be like, oh, you know, that would change a lot of things. But saying that there was glass in his nose, it still doesn't go with the Commonwealth's theory, because there was no, not Siri, I said theory. Siri trying to perk up. No. So I think that we already know that there was the broken cocktail glass that was found around him, but I don't see how a piece in his nose would support the Commonwealth's theory at all, because it still doesn't. Like I said, if it were tail light in his nose, that would be different. There are some people who are on video doing a crime, but they say not guilty and take it to trial. I don't get that, because if they don't want to plead, a lot of people will go to trial because they just want to take their chances. Maybe there's some kind of, loophole where they end up getting off, or, whatever. People will try. Lord knows we've seen them. Did he have glass in his nose at the autopsy? No, but he did have, and Dr. Scorty Bello had in her little chart that he had like a little abrasion on the side of his nose. And then remember, Buchanan, didn't he, I'd have to go back and look at my notes, didn't he call the hospital and say, or call, didn't he call somebody? I'd have to go back and look. It's been so long since I've seen that part. But remember, he said that there was some kind of domestic dispute or something, and because originally they thought he got beat up. Then he said something about there being a domestic dispute, and he was hit in the head with a cocktail glass. I need to go back and pull up those details. I can't remember exactly. I have it on my chart somewhere, but so this is not totally unlike anything we've heard before. It's just the first time that we've heard anything about this from Karen Reed, of course, about the nose. But there was a scratch on, we do know that there was a scratch on his nose. And we do know that Buchanan had said that he thought that the cocktail glass was like the weapon or whatever, So, why did she say this? I don't think she thought it through. I don't think she should have done the interviews. And I've said that all along. Not even her specifically, just any defendant. Bad idea. But, can Bev be recused from the trial? They have tried, and she refused to step down. So, she will not. She wants to stay on this and see it to the end. I think if it was me, because you can tell she's miserable in this trial. If it was me, I'd be like, all right, I'll recuse myself. Y'all going ahead with this one. I'm going to my seaside cottage. I'm not hung up on the glass in the nose. I'm not either for that reason. If it were tail light, I'd be like, oh, changed everything. But it being glass, it still doesn't go with what the Commonwealth is saying. But I guarantee, because Brennan likes to use the interview stuff, I guarantee that he has now taken that and he's taken it to his biomechanical engineer and is like, hey, can you figure out a way to work this in? That wouldn't surprise me either. That first judge was amazing. I liked that judge. I liked that it was very focused on the issue. That's not my issue. Focused on this. I liked that it was very, man, what a difference it would make if that judge were. Brandy is one person's opinion that there's something in the show that they want the jury to hear without her taking the stand. And if Brennan uses something from the show, then the defense can too. Yeah. Yeah. I mean, that would open that open that up, I'm assuming, to be able to rebut what he's saying. Or defend against what he's saying, I guess I should say. How can they get away with calling all of them as witnesses? They can't do that, can they? Ugh, I saw that he did. Like, if they did that and she ended up having to get all new counsel, it would be an appellate issue, I'm sure. Like, I mean, you can't all of a sudden have... You can't all of a sudden have brand new counsel right before trial starts. I watched it, and so far I don't see anything they could use against her. I haven't watched it yet, but how do they bring in the videos? Who talks about it? Brennan is wanting to bring in like every kind of interview that she's done. You know, all of the stuff with, and that's why he wanted like all of the notes and everything with Voss. Every single thing that she has said, he has gone through and is wanting to use it, which is kind of ironic too, because like he said something about how he's wanting to show like contradicting statements. I'm like, okay, if we're going to get into contradicting statements, like, bro, your whole witness list is a contradicting statement. Like every single thing that was done by, like, everything that was said has been, every single witness has contradicted themselves at one point or another. Not every single, most of them. So, I don't know. How are they going to get past that the lead investigator was fired? Here's the thing with that. They are going to, that should be one of the issues that we discussed this afternoon, or if they don't get to it this afternoon, then tomorrow. I hope they don't make us come back tomorrow. I have a feeling they will. If they do, then the episode, I don't know when I'll get the episode done. I don't know. We'll have to figure that out. If they do have it tomorrow, then tomorrow will not be on this week's episode. I'll say that, because there's no way I can add in. Let's not just cross that bridge when we get there. Okay, so one of the things that they had in their motions was wanting to get the internal affairs information about Proctor and all that, remember? So Brennan had opposed that, of course, and it was funny because I was reading through that last night, and let me oops. Stop pressing buttons, Brandy. I was reading through it last night, and it said something like, part of his argument was that, like, well, you know, different things could happen. Like, you know, the investigation could end and he could be, you know, exonerated or whatever. And I was like, bet you wish you left that part out now, huh? It's things that didn't happen. He's basically doing trial by media, yeah. He didn't have time to watch the first trial, but he's watched every single interview there was. When are you going to tell us some secret Beatty Churchwell news? Possibly next week. I just be pushing buttons. Stuff happens. That's okay. Just a pushing buttons. I don't believe that he hasn't watched it. He probably watched it twice. I don't know, because there's a whole lot of stuff he says he doesn't know, unless he's doing that intentionally so that he can say, oh, I don't know, I didn't see it. Just have Lucy do the episode. She's busy napping. Thank you. I went to bed with my hair wet and then did not brush it this morning. And I've gotten so I've done nothing to it and I get more compliments on it than it's so funny. When I do absolutely nothing, then everybody thinks my hair looks great. And then if I actually take time and try, everybody's like, you should get more sleep. You look tired. That's okay. I know some of y'all get dizzy from the fan. I'll cover it. OnlyFans. Woohoo! I'm finally caught up with y'all. Woohoo! Welcome. Really? You had to tell us that you didn't work hours on that? Look, no. But when I do spend a lot of time, then everybody's like, you look tired. You should just end things and go rest. I'm like, thanks. It's all right. All right. Here we go. Unmute us.
And I think we can do it. We need to spend some time talking about voir dire, so I don't want to run out of time for that. So what I plan on doing is finishing these motions by 3 o'clock. We'll give each side 2 minutes. We'll see how we do with that. And we'll try and get through this. Juror questionnaires, have you provided those? Remember we talked about it the other day? Have the two of you worked out a juror questionnaire?
I know you asked us to, we have not. We haven't spoken.
All right, so today's the final trial conference where I'm supposed to have all of this, right? Can you do it before you finish? Well, let's see where we get with the motions and we'll see about that.
And Your Honor, if I could I finish that last point that I was about to make just before we broke?
30 seconds, Mr. Jackson.
It take me 30 seconds. I want the court to be super, super clear about this one point. What Mr. Brennan referenced, and I understand why he would reference it in the transcript of the Gretchen Voss interview. The reference to the she called John and talked about Ashley's home or Ashley's house. The she was Jennifer McCabe. But on the 28th, calling John to say 34 Fairview is down the street from Ashley's house. My client was not part of that conversation. That was between Jen McCabe, as she testified, and John.
Okay.
Then the next day is when the conversation, according to Jen, took place about Ashley and could it have been some sort of an interaction or an affair or something like that.
Okay.
My only point in making this, and I just want the record to be super clear, is
I understand what your point is in making
there
it.
was no animus, no evidence of animus on the night in question.
I understand that's your position. We haven't heard the evidence yet.
Okay, I just want to make sure
all
that's
right.
clear. Thank you.
All right. Well, Mr. Jackson, you can stand up again. Is the defendant pursuing a third-party culprit defense?
That's going to be my colleague, Mr. Yannetti.
So you have 2 minutes, Mr. Yannetti. That's sort of a yes or no, and then I'll hear the Commonwealth.
And I'm sorry, I did not hear the question.
Are we going to be pursuing third-party?
Yes.
All right, so I'll hear you on your motion, Mr. Brennan, and then a 2-minute response.
2 minutes for this is wow.
Jimmy, keep track, please.
Yeah.
Go ahead.
Thank you. During the first trial, Your Honor made a ruling prior to defense presenting any evidence or questioning any witness about third-party culprit the defense needed to provide a sufficient evidence to pursue or place that issue in front of the jury. The defense, in my opinion, looking at the opening argument, ignored that directive by the court The very first words of the opening were directed to third-party culprit. And thereafter, throughout the case, there does not seem to be any boundaries, parameters, or identification of the walls or the length of third-party culprit. The varying representations by the defense over time make very unclear what the third-party culprit evidence is, whether it is a particular person, includes particular people, or unknown. We know from the defendant's statements that there was a position taken on the front of the courthouse steps that everybody knew who the third-party culprit was. That position changed in the Ted Daniels interview when they were asked about third-party culprit, Mr. Jackson, and the defendant said they did not know. And so despite the recent position that they did not know who the third-party culprit was, in our argument the other day, Attorney Little identified Brian Albert as third-party culprit, Mr. Albert. And so there is this vacillating position on who the third-party culprit is and what evidence they suggest supports third-party culprit. I took an opportunity to go back to the arguments last year for third-party culprit. I have a transcript, and it's equally undefined at that point. And so what we have now is the defense with a hope or an expectation or intention to pursue third-party culprit, but we have no basis for it. The court has been very clear on third-party culprit, and they can't just come in and start accusing people arbitrarily of committing the crime of murder. Section 1105 of the Mass Rule of Evidence makes clear that evidence that a third party committed the crime charged against the defendant.
So I will read again the Mass Guide to Evidence. I'm familiar with the law on third-party culprit. Your time is up at this point.
You see?
I've read your motion. I've read your memo.
Okay.
Or the pleadings.
Thank you.
All right, Ms. Giannetti. Jim, why don't you stand when it's done? Can you stand when it's done?
Your Honor, I can't do this in 2 minutes.
Well, then we'll hold it. We'll hold it to the end.
That's fine.
All right, Mr. Lessie, I'm going to hold you to 2 minutes. I've got the Commonwealth's motion on the Celebrate demonstration. I'll hear you for 2 minutes on that.
My 2 minutes start when I get to the podium?
Yes.
Thank you.
This is crazy to me.
The courtroom demonstration that the Commonwealth proposes is incredibly vague, and it, to the extent it can be understood, is impermissible. I'm fully aware of what happened in Trial 1. Not only did I read the transcript, I went back and watched the video. The Commonwealth states that they want to conduct, I'm reading verbatim on page 1, a courtroom demonstration of how data was stored within Jen McCabe's cell phone. That's it. No elaboration what it's going to be. They're looking, to me this is a blank check. Similarly, with regard to Jessica Hyde, we'll use a courtroom demonstration to show jurors information and data on both the phones to explain concepts and to illustrate particular information of importance. Vague, again, we have no idea what it's going to be, nor does the court. And there are similar statements, and also on page 2, they concede they want Mr. Whiffen to use the highly disputed extraction reports to demonstrate Celebrate software. It says this demonstration would closely mirror the actual Google searches, but we don't know how. It's obviously not going to do it. And lastly, with regard to the law, Section 1006 talks about the witness presenting the summary is not permitted to state deductions or inferences. That's right in the note to the rule, and that's exactly what they want them to do, is to give the deduction and the inference that the 227 timestamp means it came to at 6:30. It's in direct violation of the rule. And secondly, under 1006, the appeals court held that because the presentation selectively presented excerpts of other exhibits and evidence in such a way that it served to both bolster the Commonwealth case and rebut the defendant's case, it was not merely a neutral summary, it was more akin to an argument than evidence. The Commonwealth concedes that's the case. And with regard to Commonwealth v. Sosa, page 14, the only thing that was allowed in Sosa, the case they cite, it says the complete video footage contains several camera angles of the property. And the condensed video merely was a compilation of that which already existed. They just shortened it down. What they're proposing to do is anything but that.
All right, I appreciate your brevity too, thank you.
You're welcome.
Mr. Brennan?
Thank you. The demonstration we would be asking Ian Whiffen to engage in is the same demonstration as he did at the first trial. No different, based on the same qualifications, based on the same experience. It is essential that the jury understand and be able to see the data in action so they can appreciate the legitimacy of how the data is stored and how those windows are opened. As far as Jessica Hyde, we've provided a number of different reports. We would like to provide chalks that come directly from those reports. So if there's anything that's particularly offensive in those chalks, I'm willing to discuss it with the defense. There would be nothing new or different than hasn't already been provided. It would be simply blowing up the photographs or the exhibits in her reports so that the jury can read along and see them.
Okay, thank you very much. I'll get a decision quickly to you now. Does the defense intend to bring up any bad character or misconduct of John O'Keefe or any witness?
No, bad character evidence is inadmissible.
Right.
To the extent that evidence could be used for like motive, opportunity, all the alternative, under proposed rule 404, we reserve the right, but we would approach sidebar before introducing any such evidence, and certainly not against John O'Keefe.
What do you say, Mr. Brennan?
If we have advance notice, I think that's appropriate. I don't want to wait until we get the sidebar. If the defense has an intention of offering what would otherwise be prior bad act evidence, but they think it meets an exception under the rule, then they should propose that evidence so we have time to consider it.
Especially if you intend to open on it. Are you doing the opening, Ms. Giannetti?
I will not be doing the opening this time, and I do not believe we will be opening on that at all.
All right. So, okay. So what I'll do is not during the opening and only with advance notice and a ruling.
What would the advance notice be, Your Honor?
A week before a week before the evidence starts.
Thank you.
I'm like speechless with this whole.
Okay, that's paper 587, Mr. Clerk.
Thank you.
Commonwealth's motion for an offer of proof regarding calling District Attorney Morrissey and victim witness advocate Steve Nelson. And it also includes a request to exempt from sequestration.
Your Honor, with regards to this motion, we have no, on principle, we have no objection to an offer of proof as necessitated by the court's guidance.
Yep.
The issues do go strictly to trial strategy and attorney work product, so any such offer of proof, we would ask, we make that ex parte. I can tell the court, just to kind of streamline things, we would not be seeking either of these individuals in our case in chief. They would be merely impeachment if necessary.
Okay.
Certainly we could make those offers of proof at the appropriate time.
Okay.
Thanks.
All right. I'm satisfied with that. What's the Commonwealth's position? You satisfied with that?
I am. I would like the victim witness advocate to be able to.
Yes, the victim witness advocate, he'll be able to come in for trial.
I wasn't worried about the sequestration aspect of it. I should have mentioned that.
Okay.
Thank you.
All right, so they're both exempt from sequestration. Okay.
That's not surprising. That's kind of.
So the other motions do seem like they may take a little bit more time. I'm going to well, actually, let's try this one, see how we can do with this. So the Commonwealth's motion eliminate to prohibit reference to the pending internal affairs investigation, sustained findings, unrelated to this case or unfounded allegations. Well, this is in a little bit different posture now than when the Commonwealth filed it back on March 10th, right? With Michael Proctor being fired. Do you need some time to reconfigure this, or you want to just be heard? And for this, I'll give you both 3 or 4 minutes.
I think it would be helpful to have more time. I can report that when we learned that Mr. Proctor was fired, we filed a request for all the IA files. We included the defense, and I understand there was a production produced to us,
Oh,
to
okay.
both of us. Now, I have not seen it.
Okay.
It may be voluminous, it's something I'd like to review. I'm expecting that there may be many pieces of material in that production that is going to be relevant for the defense in this case. And if I have a chance to review it, much of it I may not object to, but there are some fundamental things I'd object to. Traditionally, ultimate findings or opinions of a advisory board or a body aren't admissible. So there will be some constant argument about what is objectionable, but I think a review of the material is helpful so we can better define what is in there and what should be admissible and what shouldn't.
All right, so you just received it. When do you anticipate being able to review it and forward at least what you feel the rules require you to forward? And then if there's anything else that I have to decide, how long will it take you to review it and provide defense counsel with everything that you believe you're required to provide them?
They have a copy of everything that we got.
Oh, okay.
So we had them on the email so they could get everything that we received. We don't have anything they don't have.
Oh, okay.
So it's really just an evidentiary argument. Can, for example, a firing, can that come in that he was fired? Can the conclusions of the board come in, whatever their position is? Maybe they found him acting unbecoming of an officer. I don't know. But those type of conclusions are what I'll probably object to. The raw material, I haven't read it. I hear it's voluminous. Need some time to read it.
Okay. How much time?
Well, I think till the end of next week.
Is that a same timetable you would have whoever's arguing for the
I don't know how
defense?
they
That's fine, Your Honor. I would just
wouldn't
ask
bring
for
that in.
notice about what specifically the Commonwealth is seeking to exclude. There were some,
Right.
even just in the motion that they filed, there's inconsistencies.
Yeah, but I think it's all different now, right?
Exactly, but there's
So-
just inconsistencies between the title and then what's actually in the body of the motion. So as long
That's
as I
the
have
thing.
clarity, then I know what to address.
Okay. All right, is this something we should come in the day before impanelment and deal with?
I'm happy to come in if the court's available.
Want to do that?
That's fine, Your Honor.
I'd rather not have anything, but I think it makes sense that we at least give you that time and then the weekend. And if you go through it, I'd like something by next Friday too. If there are materials that the two of you are disagreeing about, so that I can view it next weekend and then we can have a hearing the following Monday.
Yes, Your Honor.
Okay?
Does the court intend to have a hearing on the Monday after that? I just would like some time to be able to review their position so I can have time to respond.
So you need until next Friday. I'd like to do it before we start the trial, but I suppose we could start the trial and then hear it.
That's fine, Your Honor.
Can you
I'll move
have,
as quickly as I can. I have a lot of
Okay.
obligations over the next week. I'll try to facilitate it. I just don't know.
all right. Without knowing how much is in dispute, Ms. Little, you have no idea how long it will take you to address that, right? So,
Correct.
All right, so, Mr. Brennan, by the 28th, you're to provide the defendant with anything that is disputed, and when you, or that you feel should be excluded. And when you provide that to the Commonwealth, I'd like you to let me know as well.
I will.
All right, and then Ms. Little, why don't you tell me on April 1st how much time you need to finish up? It may be nothing, you may have it, and we can do it. So I guess we won't meet on the 31st on this?
Thank you, Your Honor. I appreciate that.
All right, so on the 1st, you'll tell me how much time you need. All right, so Mr. Brennan, since we are making good time, I'll let you go back and finish what you were saying when I gave you your 2-minute, when I cut you off after 2 minutes on third-party culprit. And then Ms. Giannetti, I'll give you both up to 5 minutes on this. 5 minutes is a long time, Ms. Giannetti. Let's see how you do.
If the court's inclined to admit the evidence, then I don't need to speak at all. But if
Well,
you're...
last time I said I wasn't excluding it, you just couldn't open on it. Right? So that's where that's where I'm at this point, and I'll hear the different sides. So,
If that's the ruling, Judge, I don't need to be heard.
and I know, Mr. Brennan, you wanted it in advance, but, you know, I guess I'll hear you on your motion on that.
The requirements of providing evidence to support third-party culprit are clear. The evidence has to be relevant, it can't be speculative, and it can't tend to prejudice or confuse the jury. If it involves hearsay or inadmissible evidence, there has to be a substantial connection between the crime charged. And so what we would want to avoid is what appeared happened in the last case when it was just a broad-based attack on anybody. There has to be relevance between who they choose as a target and the crime itself. Looking at the transcripts, I do not see that they've met a substantial basis between any particular individual and John O'Keefe. If we start from the premise that every single witness who testified that John O'Keefe never entered the home at 34 Fairview. Every witness. There is no substantive evidence that John O'Keefe ever entered that home. So to open up an invitation for the defense to start to present evidence, sometimes alleged prior bad act evidence or character evidence, is unfair because then it becomes a mini trial for each witness. And so I haven't heard any basis or any proffer by the defense that would substantiate any particular witness is a third-party culprit. Now, there are some cases that saying you don't have to actually identify the witness. Those are particular circumstances where there is still substantial evidence that an unknown person had committed the crime. That is not the case here. They have used names liberally, randomly, and those names have changed throughout litigation, whether it's in trial, after trial, but we've never seen a proffer by them. Who is it that they're going to claim as a third-party culprit? What evidence do they have that they want to introduce? There has to be parameters and limitations if they're going to try to introduce third-party culprit evidence, not only about who the person is, but what evidence are they going to introduce? Otherwise, we're going to spend half the trial at Sarbar fighting whether this is substantial, whether it's supported. And so no proffer has been made. I think there's an obligation to the defense to identify who the third-party culprit is, and what do they want to introduce? Do they have a witness? Do they have evidence? Do they have any records? Simply assailing people's character randomly is improper, it's unfair, and then it causes the Commonwealth to have to spend extraordinary time rebutting, which is going to confuse this jury, and it's prejudicial. So I think that the court should order the defense to articulate who they claim their third-party culprit is, and exactly what evidence they're going to introduce to support that claim. It's not until they articulate it we can really fashion an argument for the court, whether we think it is appropriate or whether we think it's insufficient. But now it's just an empty box where, as in the last trial, the defense can simply get up and blame anybody and everybody. And that's not the way the court and the courts have seen third-party culprit evidence. There's a standard, there's an obligation. It hasn't been met, so at this point, the court should preclude third-party culprit evidence. They shouldn't have, they could certainly pursue some type of critique on the police investigation, but as far as third party, without a proffer and a finding, there would be no guardrails, there'd be no parameters, and it would be chaos.
All right, so Ms. Giannetti, I will hear from you, and I'd ask you to focus on, could you tell me whether this is pure third-party culprit, third party as it goes to Bowden, or is it simply somebody else did it and we don't know who?
It's the second alternative. In other words...
Okay, so that's a little bit different, Mr. Brennan, not pure third-party. I'll still, go ahead, you can go over there. It's a little bit different if it's third-party as it goes to Bowden, but we know that it's not admissible if the police didn't know about that third party and not act on it. So are you going to tell us who? Last time you told me you don't have to prove that, but can
well,
you make
it's
an
still our
offer?
position that we don't have to prove or narrow it to one potential third-party culprit.
Are you saying it's several?
Three, yes.
Okay, so can you tell me the three that you say it is?
Sure. So the potential third-party culprits that we have identified are Brian Albert, Brian Higgins, and Colin Albert. I have, evidence with regard to each. I'm sensitive to the fact, Your Honor, that, and I have a lengthy argument prepared detailing the evidence against each of them.
Do you want to put it in writing?
Well, I'm just sensitive to the fact that the court is seeking not to, pollute the potential.
So we can do this over here.
It's up to Your Honor.
Why don't I see you preliminarily over there?
Well, yeah, Brian Higgins is the one that said he saw a tall, dark-haired man come in. So they've specified the 3 potential third-party culprits as Brian Albert, Brian Higgins, and Colin Albert. Colin Albert. That one prosecutor, Cosgrove, he cannot say Colin to save his life. It's Colin. Over and over. And just as a reminder, Brian Albert, Brian Higgins, and Colin Albert all have the presumption of innocence as well. We can discuss what we think. We can weigh evidence. But everybody has presumption of innocence. And we don't condone harassment. It's like my little disclaimers. She's going to throw third-party culprit. Well, yeah, I mean, they can still get it in under the Bowden stuff where it's like, there's this other potential culprit who the police should have, looked at. There was a reason for them to look at it and they didn't. But we'll see. If they're doing a third-party culprit defense and they have to introduce the third-party culprits, they have to have there's certain rules and guidelines on how they introduce stuff and what evidence they can bring in and all that kind of stuff. So if they're doing a specific third-party culprit defense, that's why they have to give that information, because they have to go through certain guidelines on how to bring that in and what they're allowed to say. What are we? It's a close-up of the latex gloves. If they are not able to bring that in, then they can, of course, go through the reasonable doubt and stuff. But in order to specifically point the finger at somebody, there's only gloves. Yes. Only gloves. The stuff with Higgins has always been the weirdest to me, because I still think it's so strange how everybody has a different story about his Jeep. And then he said something about hitting something with the plow on his Jeep. And then he went to the police station in the middle of the night with it snowing and he had been drinking. And there's so many weird things about that situation. That's always been one of my biggest questions. Like, how can some of them be so sure that they looked out and, yeah, Higgins was parked right in front of the mailbox, but then when Ryan Nagel and Heather Maxson and all them pulled up, then they're like, no, there was no Jeep there. We pulled up and we could see the black SUV in front of us. There's so, and then dumping your phone at a military base and saying it's butt dials, but you called right back. And I don't know. There's just that stuff has always been, I've just always had a lot of questions about that. I just think it's so weird. Yeah, when they show that clip, I guarantee they'll make a bigger deal about that this time too. Because they didn't really bring it up much until, I think that the part of them leaving Waterfall was more, went more towards the defense's theory than the grab-assing stuff did. I thought that stuff was, I would have focused more on the end of that video than that part, for the defense's theory. Saying that those are the third-party culprits in open court is going to piss some people off. Is Proctor the only one that was looked at to get fired? Is Higgins in jeopardy? Higgins is not in jeopardy that I know of. And also, did y'all notice that Brennan said there are certain things that he's going to object to them coming in? Like, he doesn't want the board's decision to come in. The board's decision is directly related to this case. So of course he's not going to want that in. The board literally said that based on what he did during this case, it gave the image of him being biased. And that's exactly what the defense has been saying all along. So the board fired him for doing exactly what the defense is saying that he did, and Brennan doesn't want that to come in. I don't know how that wouldn't come in, because it's literally this case. This isn't like, oh, this happened on this other case. Like, okay, in the Walsh case, you know, if they're wanting to bring that in, that's one thing. It's this case. I don't see how that wouldn't be allowed in. But, you know, with this court, you never know. You just never know. Unmute us. Thank you.
Defense has to make a decision as to what you intend to provide me so that I can make this ruling. So, all right, next is the Commonwealth's motion in limine to exclude the expert testimony of Garrett Wing. I know nothing about this person other than your motion just says that all you have is a CV. Does the defense intend to call this person?
I'm going to address that, Your Honor. How would you, I want to make sure I'm within your time constraints, so you want me to stand up?
Like 2 minutes. Just my first question is, who is this person and why haven't you complied with your reciprocal discovery obligations?
Your Honor, because this witness is pending Dr. Crosby, and he's presented because of Dr. Crosby. So it depends upon what happens with that. If Your Honor is ruling on the motion for reconsideration, then we can have a better answer to your question, but that's the purpose, is to address if Dr. Crosby is going to be allowed to testify, and if so, as to what. And we're happy to provide, once we get that determination, provide all the things that I think Your Honor has in mind.
Well, I've already ruled on Dr. Crosby, right? It's just the reconsideration, whether I think I need to rule on it or not. I'd like you to provide the discovery on this, just so we can keep things moving and we don't have to suspend the trial.
We will do so, Your Honor.
All right, so what do you say, Mr. Brennan?
Well, discovery deadlines have passed, and the Commonwealth shouldn't be in a compromised position of receiving late discovery and trying to...
Oh.
So I'd like a time certain.
Really?
You probably have it, Mr. Alessi, right? You're very well prepared. Do you have all your reciprocal discovery that you
They
need
want
to
to talk
give the
about late
Commonwealth on
discovery?
this witness?
I do not, and not only do I not have all of it, I need to go take a look at to make sure, in light of recent events, that I provide everything to the court. So I can meet a fairly short deadline, assuming I can communicate 3 days.
Can we do it by Monday?
Yes.
Is that acceptable, Mr. Brennan?
Yes.
All right.
Thank you, Your Honor.
Thank you. So 6:07, Jim, is the defendant will provide reciprocal discovery by Monday, the 24th.
I just want to throw up when he's like, when Brennan, of all people, is saying the discovery deadline has passed.
All right. Motion, Commonwealth's motion eliminate to exclude defense expert Michael Easter's opinion of the investigation. So I'll hear you on that, Mr. Brennan. I figure this is probably lengthier than the others.
I'm sorry, Your Honor?
I figured this might be more than 2 minutes, might be lengthier than the others we've heard.
The defense would like to call Mr. Easter to essentially testify about his personal opinions of the investigation, and then to purportedly give opinions about the police investigation, their failure, in his opinion, to pursue certain leads, and to give opinions about their efforts regarding writing reports. This is, from my perspective, tantamount to having a witness come in and vouch for the credibility of defense arguments and essentially summarize arguments. This really, from my perspective, is the role of the defense attorney, to cross-examine the witnesses, to point out the inadequacies, to introduce any documents they have if they want to try to impeach the witnesses, and then the witness would have the opportunity to respond or explain or admit any type failures. This is an attempt to bolster a potential Bowden defense and a third-party culprit defense. It would involve having Mr. Easter come into court and give his own personal opinions about who a target was or who a third-party culprit may be. That would be totally improper opinion and inadmissible. They would want Mr. Easter to come in and to go through protocol of the state and local police and point out what he thinks is failures. So essentially, he's a witness that would come in, promote the defense theories, tout reasonable doubt, and suggest why somebody else committed the crime. I've done quite a bit of research. This is not a summary witness. This is not a witness that has any relevance other than his own personal opinion. This former FBI agent was a full-time member of the CAS department since 2013. He is not in a position to determine the best practices of local or state. If there are different rules and regulations that the defense will attempt to introduce, that will be a separate grounds of whether they're admissible and whether they can confront the witness. And a witness always has a right to explain or challenge accusations against them. And so I see that this witness is really simply a summary witness for the defense, but not summarizing information that the jury can then digest like information in data records or phone records. Rather, a summary witness of a witness who wants to come in and give their personal opinions about this case. I don't see any grounds for admissibility for Mr. Easter to come into this case and give his opinions regarding whether he thinks the police investigation was appropriate or not, or whether he would have directed somebody to do something different and inevitably whether he thinks somebody is a suspect that was not pursued. That is all in the province of the defense in their case and in their cross-examination. So I don't see any relevance whatsoever of Mr. Easter.
All right, who's arguing for the defendant? So I need you to start by telling me what you expect him to testify to.
I can certainly tell the court that we do not expect to seek testimony or elicit testimony from Mr. Easter as to a third-party culprit.
All right, but who is he? He's a retired FBI agent?
Correct.
So what purpose are you calling him for? What's his testimony on?
To opine on the adequacy of the investigation. He is an expert as it pertains to investigations, investigative protocols, the adequacy of a proper investigation, what investigations should look like, what a proper investigation should look like.
How is he an expert on that? How is that a field, and how is he an expert on it?
I'll go through
that. Is
that.
it something he's done? Has he testified on that in other courts?
He's testified in dozens and dozens, if not hundreds of courts on issues related to investigations. He was a lead case agent for the FBI for many, many years. He taught issues concerning or taught issues specific to proper investigations and investigative techniques.
So do you have a report and CV and all that material
Yes.
that you can share with me?
Sure. I've already shared it with the Commonwealth, but I'm happy to share it with the court as well. If I think I can address many of the court's concerns as it pertains to his expertise and why the law in the Commonwealth allows, in 702, allows him, someone with his credentials, to testify to a very specific issue, like, for instance, something beyond the normal capacity of a layperson or a lay juror, and that is proper investigative techniques. A lay juror might not know, for instance, that collecting items in solo cups or grocery bags would be improper. Mike Easter certainly would know that and could opine on whether or not that followed standard protocols. What he's not going to do to assuage the Commonwealth's concerns, he's not going to or we're not going to seek to elicit testimony from Mr. Easter concerning a third-party culprit or who that third-party culprit was, but merely what investigators should do when they walk up to a crime scene and how those crime scenes should be dealt with, etc.
So is the basis of his testimony just crime scene, like collection of evidence, or is it
witness interviews?
When somebody tells you somebody may have done it, you're supposed to go follow all those leads? Which is it?
That too. Both. Because if someone tells you as an investigator someone else may have done it, you're supposed to follow that lead. That is a proper investigative technique. Of course it is. But it also includes, as the court just noted, things like cordoning off the crime scene, maintaining proper logs, evidence recovery, evidence photographing, logging materials that are moved from the crime scene over to the crime lab, how that's supposed to be done, what types of logs are kept and why those logs are kept, how you bag evidence, how you secure evidence, how you maintain the integrity of evidence, and things of that nature. There is certainly, I would indicate to the court that 702 in Massachusetts mirrors very specifically 702 in the federal courts. It's literally, I looked at them side by side, they're nearly word for word. And the advisory committee notes for Federal Rules of Evidence 702 is very, very instructive on this particular issue, specifically as it pertains to somebody with the expertise in a field like crime scene investigations and investigative protocols. And what the advisory committee notes say is, quote, 702, the rule is broadly phrased. The fields of knowledge which may be drawn upon are not merely limited to, quote, scientific and, quote, technical, the scientific and the technical, but extend to all specialized knowledge. Similarly, the expert is viewed not in a narrow sense, but as a person qualified by knowledge, skill, experience, training, or education. Thus, within the scope of the rule are not only experts in the strictest sense of the word, for example, physicians, physicists, and architects, but also the large group sometimes called skilled witnesses, such as bankers and landowners testifying to land values. Now, again, obviously, we're not dealing with a banker or landowner, but the advisory notes and the advisory committee on the Rules of Evidence 702, the Federal Rules of Evidence 702, clearly lay out this is exactly the type of field that is subject to expert opinion. Clearly, the Rule 702 allows for experts with specialized experience, specialized knowledge, specialized education, beyond that of an average layperson, in particular, in a field without, or in a particular field, without resort to, for instance, the generalized scientific methodology that we've heard so much about in some of these motions in limine. I can go through some of his credentials, but Mr. Easter is eminently qualified to provide the jury information about proper and accepted investigative techniques and protocols. As the court noted, or as I just noted to the court, he was an FBI special agent for more than 20 years. He formally coordinated with multi-agency investigative gang task forces in Los Angeles. He worked with multiple agencies responding to dozens of crime scenes, including shootings, stabbings, abductions, child abductions, both domestically and internationally. He was the lead case agent who oversaw arrests and indictments. He received awards and recognitions for his work with the FBI, as well as with state agencies in which he was a task force member. For 11 years, he primarily assisted homicide detectives from LAPD, the Los Angeles Sheriff's Department, and the Los Angeles District Attorney, numerous other agencies as well, state and local agencies, with investigations and prosecution of thousands and thousands of homicides, robberies, kidnappings, other violent crimes. His work and assistance on investigations in LA and across the United States and ultimately internationally has been noted by not only the FBI, but those agencies as well. Just a few of Mr. Easter's experiences and involvements in some of the domestic and international cases include the 2015 San Bernardino mass shooting.
So are these all on his CV that you're going to give me a copy of?
Everything, I believe, all
I don't need you time again of the restraint. If you're going to give me a copy of the CV, I can read it. You don't need to recite it.
It's either, what I was reciting is either in the CV or in his report. One or the other.
That's what I need. That would be much more helpful to me.
Then I don't know what more the court would like for me to
I
have
wanted to know specifically what you intend to have him testify on, but if it's in his report,
it's in his, it broadly is in his report. I don't know exactly every question I'm going to ask him, but I can tell the court in broad brushstrokes. Obviously, we're going to ask him, we've already asked him to review, he's reviewed NOD 1 through 59. We're going to give him the additional NODs that we've got as well. He's going to review everything. And from that, he's going to, I expect, render an opinion about whether or not the investigation followed standards and training, best case practices for an investigative technique.
So I guess that's my question. So without seeing the report, where are their standards and best practices? Is that something that somebody can turn to and see codification of it, or is it just his experience?
No, it's not just his experience. Those standards and practices are oftentimes reduced to writing. They have been reduced to writing with the Massachusetts State Police. So he's reviewed the protocols that are in place for the MSP.
Okay.
He's very familiar with FBI's protocols for investigative techniques and investigative protocols. He'll utilize those skills and that knowledge base to assess his opinion, or to render an opinion and a conclusion concerning what he believes are the proper protocols that should have been followed in this case. That goes directly to our Bowdoin defense, and he is the primary expert that we would use to propound that Bowdoin defense.
All right, can you get me that report before you leave? Do you have it extra?
I think we probably have an extra copy of it, yes.
Mr. Brennan, did you want to respond?
Mr. Easter was a agent who did CAST. He did the CLSI. He may have been in hundreds of cases. I'd like to know what cases he's come into court and given his subjective opinion about how he feels an investigation was done. Not a report, not an assignment, but as an expert witness in Bowdoin. How many cases has he gone into court and testified and been allowed to testify about his personal opinion? His experience in the FBI is different than Canton Police Department and the state police. This is just Monday morning quarterbacking, and it's an attempt to bolster argument by counsel so that they can use some type of opinion to lean on when they're arguing to the jury they should have doubt because of the police investigation. I don't see any recognition under 702 or in law where somebody can come in and subjectively give their opinions. If there is a state police protocol that wasn't followed, then the defense can see if that state police protocol is appropriate. If they're speaking to a state police officer, question them about it and ask them if they did it and why. If this person comes in and gives opinions, there'll be a slew of opinions that are shot like a shotgun approach that we'll never be able to have an opportunity to explain. Are we going to call in the Canton Police Department again and call in the state police for a second round so they can explain why they chose certain actions that Mr. Easter is criticizing? I don't think this is an appropriate ground for an expert witness. I don't see any cases, I've looked through the state and federal court, that allow an expert to come in on a Bowden defense and give their subjective opinion about an investigation they weren't involved with. I don't know that this witness has ever been qualified as a Bowden-type witness in any court. He may have testified, but about what? And so I think this is a very dangerous proposition. What if the Commonwealth wants to counter and bring in a state police officer to say that the investigation was fantastic, that everybody did a remarkable job under the circumstances? What if we bring in a witness to talk about the fact that the evidence is so overwhelming that it should imply a certain finding by the jury? This invites that. This invites a debate between people's personal opinions. That's done outside of the courtroom, not in a courtroom. We will never have an opportunity to be able to have all the witnesses come back to explain what this witness subjectively thinks was a deficiency. I don't think it's appropriate for expert witness testimony. This is argument by counsel.
You know, very briefly, I gently disagree with Mr. Brennan. He indicates that we want to use an expert to bolster our argument. There's another word for that, or another phrase for that. It's called presenting a defense for someone charged with murder. He indicates, well, what are we going to do? This guy's going to get up there and testify. What am I supposed to do? Call a bunch of other Canton PD officers to talk about how great their investigative techniques were? Yeah, there's another word for that. It's called rebuttal. That's what you're supposed to do. And then he says, well, hang on.
You wouldn't be objecting if they called somebody in rebuttal to reinforce a great investigation?
Oh, no. Oh, no. Mr. Brennan said, what if I called a Massachusetts state police officer to say that this was the best investigation ever? I have two words. Do it. Do it.
He would love cross-examination of that.
A shot at that.
So I said, let's take personal.
That's not an invective. That's not a personal shot at Mr. Brennan. I'm just saying, do it. You want to call in another expert? That's a classic battle of the experts. That's fine. I'll put Mike Easter up against any expert they want to call. But the reality is, Your Honor, we are entitled to present a defense. And part of that defense, the Bowden defense, is the adequacy of the investigation. And there's no question that a proper homicide investigation is not something within...
I don't know. So if you can give me a case site for that, all right, that expert testimony regarding a Bowden defense, I've never seen it. I've never seen it in research or anything. So
I've got
like a case site.
There are certainly cases outside the jurisdiction.
Yeah, Massachusetts case. If not, you can give me the outside cases, but I don't believe there's a Massachusetts case where this has been done.
We have searched and searched for a specific case in Massachusetts. To my finding, to our finding, there isn't one directly on point, but there are plenty, there's a myriad cases outside the jurisdiction where investigators are called consistently, especially on behalf of the defense, to talk about adequacy of an investigation.
Right.
That is an expert field, one that's utilized throughout the country all the
So I need
time.
some authority, and the more persuasive the authority, the better chance you have at this. Okay?
Sure.
All right. So I think that's it for the motions in limine. Did I miss anything? All right. Well, I need that. Oh.
Your Honor, earlier you alluded to this, when defense wanted to talk further about the ARCA issue, the Rule 14. You said we'll wait for, we'll put that off until the end, if I heard you correctly.
I thought you and Mr. Brennan were going to talk about it first. Is that your understanding, Mr. Brennan?
Yes, and we have none.
Yes. So that was my understanding. So impanelment, you don't have anything for me for impanelment?
I regret we don't. We have not spoken.
Your Honor, if I may, on one point on the impanelment.
Sure.
I just know it's the court's preference to have a one-page front and back questionnaire.
Yes.
I was wondering if, in light of the unprecedented pretrial publicity in this case, if Your Honor would consider an additional one-page juror questionnaire that deals with just pretrial publicity. Last month in the Chisholm case, the SJC outlined kind of appropriate questions.
Right.
If in additional to the front and back, there was just one questionnaire that focused just on pretrial publicity, I think that would expedite the impanelment process.
I think that makes sense. Is there any objection from the defense on that? There's been an extraordinary amount of publicity, even far more than the last trial, and so close to jury impanelment, it makes sense to me.
I'm sorry, Your Honor, I was looking for outside cases. No, there's no objection.
All right. So I need the joint questionnaire, and it can be that third page, Ms. McLaughlin. I think that's a great idea. And I was thinking about Chisholm earlier when I was expecting something from the parties. All right. File your questionnaire, file your proposed questions that you would like me to ask the venire and that you would like to ask at sidebar. I need that by tomorrow. So tomorrow by the close of business, I need that. So if I need to see you again next week, we'll let you know on Monday. All right?
Yes, Your Honor.
Okay.
Well, obviously, it would be a day after Monday then, right?
Yes, Mr. Unit, it will be after Monday.
We did file 2 motions today that at some point we'll need a hearing on.
Okay.
The defense just received notice this morning, so they're not prepared for today, but we would want a hearing on both of those motions. The sooner, the better for us.
So why don't we come in next week?
They filed 2 motions. What motions did they file? Have I seen that? I don't think I've seen that. Yeah, isn't that wild? What 2 motions did they file? Well, I saw that they added the defense to the witness list, but that's not a motion. So now she's talking about coming in next week. So when? Yes. That is correct. Yeah, they're done, but she's talking about coming in next week. So I was trying to hang on and see when she's planning on doing that.
So I will see counsel on whatever is outstanding next Tuesday, the 25th, and we'll do that at 11 o'clock. All right. Okay, thank you very much.
Thank you.
Court, all right, please.
All right. Tuesday at 11. What is that? 20? Hold on. 25th? All right. So, what are we thinking? How are we feeling? I don't know what motions were filed. Let me see if it's, I doubt it's on the docket already, but I will check just because I'm nosy like that. And then I'm going to take off so that I can get started on adding this to the podcast so that I can still get the podcast out tomorrow. Hopefully tomorrow, maybe Saturday. It depends on how long it's going to take me to add all this stuff in. Subscriber for 13 whole months. Best channel on YouTube and best podcast. Thank you. Thank you. Thank you. Thank you. Masscourts.org. Superior Court of Norfolk County. They're about 5011. This says, so for today, it says, defendant not in court, intervener, Aiden Carney, present along with his attorney, Tim Bradle. Defendant enters while hearing is in progress along with counsel, Yannetti, Little, Alessi, and Jackson. Intervener. It's been called worse. Okay, so the Commonwealth filed an amended, my stomach's growling, y'all hear that? You probably don't hear it. An amended witness list, prospective witness list. That's it. So whatever he has turned in is not showing up on the docket just yet, but I will keep an eye out, and whatever it is, we will be talking about it next Tuesday is what it looks like. So, do we think AJ will do the opening? I think so. Because when Yannetti said something about how he's not doing the opening, did you notice he looked over at Jackson when he started talking about it? So I think that Jackson will probably do the opening. Just based on that. And Alessi, because, I mean, think about it, like, Alessi is not the right one to do the opening because he's like, his specialty is like the technical stuff. Jackson's specialty is the storytelling, the charisma, you know, keeping the jury engaged. I think that it would end up being him. But we'll see. We'll see what happens. I spam the podcast in everybody's chat. I go in, thank you. Thank you. Thank you. Hank Breenan's deviated septum is livid. Me too. Hank Breenan's deviated septum. Bye, Shanka. Tell Bacon Bit we say hello. See you next Tuesday at 11. Thank you, Chrissy Bacon. Thank you. Thank you. Goodbye, Melissa Pilson. Goodbye. So we did get through a lot of stuff today. A lot of those motions. There are so many motions. So many motions. Motions in lemonade. Emotions in lemonade. There are so many of them. And like a wild amount. I can't remember a trial where I've ever seen this many, which is interesting. So I don't know. We'll see how it goes. But we did make it through a lot of them today, and yesterday, not yesterday, the day before yesterday, whatever. There's a lot. So, and there's still a few more, I guess. Oh, my stomach's growling so loud. I need to eat something. My yogurt has worn off. So I am going to get to work on the podcast episode so that we can get it. I can try to get it out. I'm going to take a little break first and eat. Let the dogs out. Where are the dogs? Oh, Emmy's asleep over there. And then I'm going to start, yes, lemonade and red Solo cups. Emotions and lemonade in red Solo cups. I will see y'all on Tuesday. I will get the podcast. My goal is to get the podcast episode out tomorrow because I would like to have an actual weekend. I've been trying to take actual weekends because I know I won't have weekends when the trial starts. So I'm trying to take actual weekends without work. So that's my goal. So I'm going to try to have the podcast out tomorrow. If I don't have it out tomorrow, it will be Saturday. But I am going to work as late as I possibly can tonight to see what I can get done. It's a lot, y'all. And next week, we'll be back at 11, and I am hoping that they address. I wonder if the defense knows that they just got added to the witness list. I feel sure they probably do. Did it happen before lunch or after lunch? I don't know. We'll have to find out. Very interesting. I'm still laughing about Brennan bringing someone. I know when he said that, and when Jackson was like, 2 words, do it. I was like, heck yeah, Jackson would love to cross-examine somebody who gets up there and says that that's how things were supposed to be done. He would love that. Maybe, okay, today got wild and they got a little spicy, little sassy. Sassy pants were everywhere today. Courtroom was full of sassy pants today, but maybe now that the judge has said, like, let's leave the personal stuff out of here, maybe they will tone that down some. I'm talking to you, Brennan. And leave it out of, maybe that's like his sign to like leave it out of the theatrics, out of the, even in the dang, he even takes those little digs in his motions. If you notice, like he'll even put some of those little digs in his motions. So, interesting day. The 2-minute thing was very interesting too. Yeah, Brennan keeps poking the bear. Yeah. You can only do that so much before, bear fights back and turns all. What's that movie with Leonardo DiCaprio with a bear? The Revenant? Okay, my stomach's growling. I need to go get a snack, and then I'm going to get to work on the episode. I appreciate all of y'all. Thank you so much for hanging out. Thank you to everybody who shared your memberversaries. I am so glad to have you all here. Mama Smith member, speaking of which, Mama Smith member for 13 whole months. So happy to see your beautiful face more often. I'm happy to see your beautiful profile more often. I can't say your faces because I don't really get to see your faces, but I get to see your beautiful screen names. Even you, I guess, yeah, sometimes. But I appreciate all of y'all. I hate to rush off, but I have, based on what we've been over today, I have a lot to get done so that I can have this episode out. If you have not checked out 13th Juror Podcast, please do. I have some I have all kinds of things happening with the podcast that I'm very excited about. So I'll be able to share more information with y'all soon. But I love you all. And Lucy and Emmy say bye. Okay, well, maybe you can see, well, it's fuzzy, but oh wait, hold on. If I put my hand right here, you can kind of see that paw. See her baby paw. That's Emmy's paw. Thank you, Silver Swag. Get some rest, woman. I plan on it. I'm hoping that tomorrow, if I can get done with the podcast, I'm hoping that tomorrow can be a day of rest, or Saturday, or Sunday. One day. I just need a day. I need a day. I will see y'all on Tuesday, bright and early-ish. Thank you for the super chats. Thank y'all for being here. Thank you for all of your support. I love each of you. Y'all are the best. Mods, y'all the best. I love y'all. I will see you Tuesday.
Yeah, I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Goodbye, good people. Now, how the heck do I get out of here?